We are.
Yes, and we're recording.
Thank you, Shannon. Good morning, everyone, to the Council on Access and Fairness meeting. Can I have, Shannon, can I have you make the housekeeping announcements?
Yes. Welcome, committee members, liaisons, and members of the public to the Council on Access and Fairness meeting. Thank you for joining us. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raised hand feature. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. A friendly reminder that this is a video conference, and so please be aware of your surroundings behind you. All committee meetings will be recorded and posted to the State Bar website. Zoom captioning is available. To enable, select Live Transcript at the bottom of your Zoom screen, then select Enable Auto Transcription. Thank you.
Thank you, Shannon. Good morning again, everyone. I'm going to go ahead and call the meeting to order. It's nice to see you all, some of you in person, some of you on Zoom. It's been a little while since we saw each other. I should, I guess, Elizabeth, ask you to take roll to make sure we have a quorum.
Yes. Adebo Mary. Coleman.
Present.
Davis.
Present.
Hill. Higgins. Richards.
Present.
Salceda.
Present.
Santoro. Rhodes.
Here.
Rosie.
Here.
We have a quorum.
Thank you. For those watching, you can see we're using Zoom name tags to make it easier to recognize who everyone is in the meeting. So hopefully that will help anyone who is watching today's meeting. At this point, I'd like to call for public comment. As a reminder, the State Bar encourages folks to send public comment in via email so that COAF and State Bar staff can see it before the meeting. But we will take time right now if there are members of the public who wish to speak. Let me let everyone know that we did receive public comment prior to this COAF meeting. That public comment was related to the Business and Profession Code sections 6060.7 and 6046.7, which is an agenda item on the CBE, the Committee of Bar Examiners meeting today, and not something that will be on COAF's agenda. But we did send that around to COAF members so they could see it anyway. And then Elizabeth, I think that you wanted to add.
Yeah, so we did receive public comment late last night, written email to us, and so staff will email that out to COAF members after our meeting today. Oh, and I wanted to acknowledge our board liaison, Sarah Good, has joined us.
Good morning, Sarah. Nice to see you. Wish you were here with us.
Good morning, everybody. I didn't know you were going to be in San Francisco, or I could have joined you.
I'm sorry I didn't let you know in time.
And I think that it seems like Yemi is joining us as well. If you want to add her to the role. Hopefully she's able to make it in. Okay, while that is happening, I'll go ahead and take any public comment if there is any. As a reminder to members of the public, we limit public comment to 3 minutes per person. Shannon, do we have any members of the public that wish to make public comment?
No, there are no hands raised.
Okay. All right, then we will move on to approval of the minutes from our December 1st, 2023 meeting. Does anybody have any edits or comments about our meeting minutes? Seeing no one jump in, would someone like to make a motion to approve the minutes?
I'll move.
Thank you, Judge Rhodes. And would someone like to second that?
I
I'll
second.
second.
Many people will second. I saw it was Shalak and someone else, but
Okay. Thank you.
we'll go with Dean Richards on that. All right. Elizabeth, can we take a roll call vote?
Adebo Mary,
Still be trying to.
hi Yemi, can you hear us? Okay. Coleman,
Yes.
Davis,
Yes.
Hill, absent, Higgins, absent, Richards,
Sorry, yes.
thank you. Salceda,
Yes.
Santoro, absent, Rhodes,
Yes.
Rosie.
Yes,
Motion carries.
thank you. Okay, well, again, good morning, everyone. This is the report from the chair portion of our agenda. I wanted to say a handful of things. First of all, again, it's nice to see everyone. We haven't seen each other since December, and some of us have just seen each other on committee meetings, but it is nice to see you all. You all should have received an email from Elizabeth reminding you that we need your help in filling the 4 vacant positions that we will have on COAF starting next year. So I roll off, sadly, at the end of the 2024 term, as does, I believe, Novella. That's right, Novella, and then
Shalak,
Shalak would roll off. And I feel like there's somebody else who should, oh, Stephanie.
Stephanie and Michael.
Oh, Stephanie and Michael. Oh,
Potentially.
that's a lot of, okay. Right. As a reminder to folks who are here and might potentially roll off, you are permitted by state bar rules to stay longer if you are the chair or vice chair. Keep that in mind, but we will have vacancies to fill and we need your help in doing that. So please reach out to other associations that you are members of, your friends, colleagues that you know, really anyone on the street, people who you think might be interested in joining COAF. We do rely on our members to help spread the word. And if you know the folks who you think would be great on COAF, please let them know. The application deadline is April 15th. The application information is on the State Bar's website, or Elizabeth can send it to you. I think it was also in the email that she sent out a couple weeks ago. So if you need it again, please let her know that and we can get that out. So that's the first thing that I'm gonna ask of everyone. The only other thing I think that I wanted to let everyone know about is that our next meeting, which is at the end of June, the 28th. Thank you, good, see, June 28th. That will be our second in-person meeting of the year. We will be in Los Angeles at the State Bar office in Los Angeles on June 28th. So we encourage everyone to attend in person if you can. We don't really get to see each other very often in person anymore, and it would be nice if you're able to make it to the State Bar office. We will all be there together, and that would be nice. I don't think I have anything else to share on the report from the chair. Anybody have questions or about the application process, or I think that is it attorneys and members of the public that,
That's right.
so it doesn't have to just be attorneys. But seeing no questions, I will move on to our next agenda item, which is a report from our program director, Elizabeth.
Thank you. So I just have a few quick updates. So there was a recent State Bar staff reorganization that impacted the Office of Access and Inclusion. Bridget Grammy now oversees the Office of Access and Inclusion, so you may see her more involved in some of our work moving forward and attending our meetings. And I also wanted to note that the Committee on Judicial Nominations Evaluation, the Jenny Commission, now sits in our office. So it's been very exciting to be able to support that work as well. And just as Judge Kristen mentioned appointments, the appointments are also open for the Jenny Commission. So I thought I would put a pitch out for that as well. Moving on, the Legal Aid Leaders Fellowship Grants update. I want to thank Kristen and Novella again for their participation on that grant review committee. For summer 2024, we will be able to support, along with the Legal Services Trust Fund Commission, 70 law students at legal aid organizations throughout the state. So we're very excited about that. We are partnering with California Change Lawyers to provide support to the students in terms of additional trainings, networking opportunities, and Change Lawyers will also be funding some fellows as well. So we will increase the number in that cohort. So that's very exciting. The statute authorizing this funding expires at the end of this year. So the State Bar is working on requesting that the statute be extended. Just a little bit of detail on that, on the State Bar licensing fee statement, there is a $45 opt-out donation for legal services, and $5 of that $45 goes towards these fellowships. I believe one of our requests is to increase that to $10 of the $45 to go towards these fellowships, which would increase our the amount of money and amount of fellowships that we could fund. So if that all goes through, that would be very exciting to be able to basically double the amount of fellows we can fund. So more to come on that as we move forward in that process. And then I know that COAF in the past has provided a lot of support and feedback in looking at the State Bar's attorney census. And this is an optional survey that is available to all attorneys on the My State Bar profile. We are going to, our colleagues in the Office of Research and Statistics are going to be looking at the attorney census questions over the next several months. And so I would like to ask for 2 volunteers to participate in a working group on that. You can raise your hand now or reach out to me later, but I do think this is a great opportunity to be able to look at the information we gather and be, I think, more intentional and inclusive in that process.
I'm happy to volunteer for that.
I'm happy to volunteer as well.
Okay, thank you.
Thanks. I'm sort of burning the candle at 2 ends here, so sorry I'm a little in and out, but I'm here. I'm happy to volunteer for that.
Okay, thanks, Yami. Okay, great. And so and that's my update for now.
Thank you, Elizabeth. Thank you, folks, for volunteering as well. All right, so we're going to move to item 6.1 on our agenda, which is a presentation from Chief Trial Counsel George Cardona, who just logged in. Thank you, George, for being here. This is a discussion about Rule 8.4.1. And George has a presentation for us.
I do, which hopefully you can now see. If someone can just put a thumbs up or something, excellent. All right, so I was asked to present again on kind of data on our complaints we receive under Rule 8.4.1. So as a quick reminder, Rule 8.4.1 has basically 6 different types of violations or 6 allegation categories. It prohibits representing or terminating or refusing to represent a client, unlawfully harassing or discriminating on the basis of any protected characteristic, or unlawfully retaliating. And then in connection with law firm operations, it prohibits unlawfully discriminating on the basis of any protected characteristic, unlawfully harassing an employee, applicant, or others on the basis of a protected characteristic, unlawfully refusing to hire or employ based on a protected characteristic, or unlawfully retaliating. So we have been tracking as we receive complaints in with these different types of allegations. And so now this is the data updated through December of last year. The rule was put in place effective November 1st, 2018. So we have the data showing the number of allegations we have received in total under Rule 8.4.1 and what has happened to them. So it's a total of 932 allegations. Importantly, that's not individual lawyers. It's actually counting the allegations under Rule 8.4.1, and an individual attorney could be subject to multiple allegations, either in a single complaint or multiple complaints. I'll have data later on individual attorneys, but for now, this is on allegations. So you can see the total number we've received. The total is 932, of which the majority, 66%, are closed in intake, 26% in investigation, 8% remain open pending investigation or in some other stage, and 1 received discipline during this period, and I'll come to that one later. This is roughly consistent with our overall statistics. Generally, we close somewhere between 60 and 63% of our complaints in intake, roughly 34% in investigation, and then the balance move forward to consideration for charging. So this is roughly consistent. In terms of allegation types, you can see that by far the most we receive are under 8.4.1A1. And as a reminder, that's the in representing or terminating or refusing to represent, unlawfully harassing or discriminating. So that's the most we receive. And then you can see kind of the outlines of the others. And this shows the disposition as well. So you can see that the one that we actually filed discipline in was one where the allegation was an 8.4.1A1. And then you can see the numbers across that. By year, just so you can get a sense of the trends, these are the total number of allegations received each year. So obviously the rule was put in place in November of 2018. So we had very few come in 2018, just 1. And then gradually the number has increased, and it seemed to plateau right around here, somewhere around 250 allegations each year for the last 3 years. We'll continue to track that and see if in fact that does suggest a leveling out, and if that's kind of what we can expect each year going forward. In terms of the one discipline case we had where we actually filed something, it was originally opened in our office as a possible allegation under Rule 8.4.1A1. Ultimately, a stipulation was reached and discipline was imposed based on a violation of Rule 8.4D, conduct prejudicial to the administration of justice. There were a number of mitigating circumstances present that ended up in being a public reproval. Here's the description from the stipulation of the conduct. It involved a lawyer who in court on the record seeking by his explanation to make a joke for someone who he knew would be reading the transcript, directed a derogatory epithet, quote, "See you next Tuesday," at the opposing female attorneys, concealed from the judge what he was doing, resulting in the judge ultimately, after it was brought to his attention by the female attorneys, holding a couple of hearings to sort out what had happened, what this meant, whether the lawyer intended it, found that the lawyer did intend to do it, that it was intentional, that it was an intentional effort to introduce a derogatory epithet onto the record. And as a result, the stipulation was that this constituted conduct prejudicial to the administration of justice, in that it undermined public confidence in the legal system and interfered with the proper functioning of the proceeding by forcing the court to waste time on hearings that otherwise wouldn't have been necessary. So that's the one case in which we've actually proceeded to discipline. In terms of individual attorneys, so took the data for the allegations and now have isolated it down to individual attorneys. So there is a total of 742 individual attorneys, distinct individual attorneys who have faced allegations under 8.4.1. Importantly, each attorney may have been the subject of multiple allegations, either in one complaint or multiple complaints. So we have narrowed the data to isolate individual attorneys. In doing so, there can be some minor skewing of the data. In other words, there could have been an attorney with 3 closed allegations and 2 open allegations. And as a result of how we looked at the data, that might show as the attorney simply having 1 closed allegation. There should be a fairly minimal impact on the overall statistics because it should even out across the different individual attorneys the way we looked at the data. So in essence, of those 742 attorneys, you can see that 501 were closed in intake, roughly 608%, 193 were closed in investigation, 1 was disciplined, the one we just talked about, and we have open matters on 47. We can look across time, and again, you see kind of the same trend with an evening out. It looks like somewhere around the 175 to 185. And again, we'll move forward to see if that's what we see on an ongoing basis as allegations are made across time. So the request from last time was to provide some additional information on the demographics of the attorneys who are the subjects of these types of allegations. And so we've pulled that data. So again, this is based on individual attorneys. So this is the 742 total attorneys who faced at least 1 allegation under 8.4.1 over this entire time period. And for those attorneys, the demographic breakdown by gender, 64% male, 31% female, 2% other, and 3% for whom we had no information because they declined on the available sources we have to provide information. So if you're looking for a comparison on that from the ADR that was filed this year, for active attorneys, 42% are female and roughly 55% are male. If you look at gender by attorneys who have had at least 1 complaint filed during the year, for female, it's 30%, and for male, it's 65%. So you can see that our numbers are generally consistent with those 2 comparison sources that we have from the ADR. If we turn to race and ethnicity, the breakdown is this. You can see that 66% of the attorneys who had at least 1 allegation were white. The next highest was Asian American, 8%, Hispanic Latino, 7%, multiracial, 6%, other 5%, no information 4%, and Black African American 4%. Again, if we look at the comparative numbers from the ADR, for Asian American attorneys, the percentage was total percent of active attorneys is 13%. The number of percentage of attorneys who had at least 1 complaint against them during the year was 8%. For Black African American, the active attorneys were 3%. The number with at least 1 complaint were 5%. For Hispanic Latino, the number of percentage of active attorneys was 6%. The attorneys with at least 1 complaint was 8%. And for white, the number of active attorneys was 65%. The number with at least 1 complaint against them was 64%. So again, you can see that the percentages are roughly consistent with those kind of comparators from the ADR for the populations that we're looking at. Oh, sorry. We also did, and I can't remember if this was asked for, but we went ahead and pulled all the data we could. We also looked at attorney firm size to see if there was information there. So here, the firm size for people who reported that they were solo practitioners, in essence, their law firm was 1, 27%, which is the largest number, 2 to 5, 20%, and then smaller numbers across. Importantly, 6% we had no information and 10% indicated that this wasn't applicable to them. I don't have comparators for this right now, but that's the data for the 8.4.1. And again, this is an attorney who had at least one allegation of 8.4.1 against them during this time period. We also pulled the data for employment sector, and you can see here, people who reported they were in a law firm of 2+, 37%, solo practice 28%, no information 6%, not employed 3%, and then these other sectors, you can see the numbers there. Finally, we also pulled years in practice, and here we see the largest number are people who have been in practice for 20 to 39 years, 44%, 5 to 19 years, 38%, 40+ years, 10%, and under 5 years, 8%. And again, I don't have the comparators for that. I'll see if I can locate anything that we could use as a comparator for that. But those are the numbers with respect to the attorneys who, again, had at least one allegation under 8.4.1 against them during this time period. And I think that is all the data that we had in terms of demographic data for the attorneys who were subject to an 8.4.1 allegation. So that's basically the data. I'm happy to try and answer any questions if anybody has them.
I am guessing that I have some, and I'm guessing that other members of COAF might have some as well. George, can I ask you, in the discipline case, do you know if the judge filed that case or if it was filed by one of the attorneys?
I would have to look back.
Okay.
I just don't know.
Okay. And then when you were talking about the demographic information on gender, there was another category. Is that non-binary? Or what? How are we distinguishing other here?
I think it's a self-reporting thing. So I think there are boxes that people can check where they either check female, male, or other.
Okay, and that's done by the person filing the complaint as opposed to the
No, the demographic information that we drew was from our attorney records. So that would be reported by the attorney themselves.
Got it. Okay, thank you. Thank you, that helps. It's hard this way. I think Angelica has her hand up. It's trickier this way because George slides.
So I can take this down, and that way you can see everybody.
Great, thank you, George. This is great, by the way, and I really appreciate it. I don't know if Elizabeth has this slide deck, but
she doesn't yet because I finished it last night. So
yep, okay.
So I will get it to her in a PDF form that you can circulate.
Thank you.
Thank you, George. That would be really, really great. Thank you. Angelica, you have your hand up.
Yeah, I was just mostly wondering for a typical investigation, just like the timeline, like how long does it take to resolve? I'm sure it depends on the facts and everything, but if you have sort of an average and the type of resources in terms of like, is this one person tasked with the investigation?
Sure.
Yeah.
So for cases that are closed in intake, typically those will be closed within roughly 30 to 45 days. Basically, that's based when a complaint comes in, it goes to our intake section. It's assigned to an attorney to do a review to determine if the complaint basically alleges facts sufficient to state a violation or sufficient to indicate that there are avenues of investigation we could pursue that might demonstrate a violation. So it's basically a quick review of the complaint. There might be a request back to the person who submits the complaint for additional information if there appear to be gaps in what they've said. And then a determination is made. So that's basically on the face of the complaint and or any additional information that the complaining witness provides us. So that's why that's fairly quick. If there is a decision to move forward to investigation, then it's assigned to an investigator and an attorney. Generally, it's one investigator, one attorney who then have responsibility for investigating that case. That investigation can take a number of forms. It typically will include interviewing the complaining witness or obtaining additional information from them. If there are other witnesses identified, reaching out and speaking with those other witnesses. And then we are required to provide the attorney, who is the one being complained about, with a summary of what we've found in the investigation and give them an opportunity to respond to those allegations. And we typically will also ask them for information and their side of the story. Then we take all that information, evaluate, and make a decision as to whether to move forward to charging. The time there can vary tremendously depending upon what needs to be done in the investigation. We try for most cases to try and complete that investigation within 180 days so that we have the ability to make a decision within that. That's the statutory time frame in which we are supposed to try to resolve most of our complaints and investigation. If it's resolved and if it's closed an investigation, then it ends. There are things we can do in investigation to resolve matters that result in them being closed without public discipline, but with some action taken. So we can issue a warning letter to the attorney. We now have a diversion program that we can use if we believe that there's something there, but not enough to proceed to discipline. If it does move forward to the charging stage, the attorney and investigator would typically continue to work on it. It might be transferred to a different attorney for handling for trial. They would then complete the investigation, put together the charging instrument, and then under the rules, we are required to provide the attorney who is the subject of the complaint with the opportunity to have an early neutral evaluation conference, which is a conference with a state bar court judge in an effort to see if we can resolve the case without trial. That might result in a resolution. If not, the charges would be filed and we'd proceed to trial. Ideally, if it is going to move forward to charging, that should be completed as well within 180 plus days. But again, that varies depending on the nature of the case. Sorry about that long answer, but hopefully that gives you the information you wanted.
No, that was very thorough, George. Thank you.
I have a follow-up question.
Yes.
I have a follow-up question about, I guess it's who's making the complaints. And I know that 8.3 is relatively new, but whether some of these complaints are coming through 8.3 referrals from other attorneys or just general referrals or complaints filed by other attorneys versus members of the public versus judges. Do we have any sense of where the complaints are coming from?
I don't have that information. I would have to go back and see what we could do in terms of generating that information. I haven't asked for the data to mesh this with our tracking of 8.3 complaints. But I can see if we can do that.
I want to defer to the rest of the committee before I personally ask you to do that. Because I know that it's quite a bit of work, George. So I appreciate your even offering.
Yes, Shalak.
Yes, George, I know it's quite a bit of work, but I'd also be interested because I think one of the concerns that the committee had was whether or not, for lack of a better word, 8.3 could be weaponized in some ways. And so
Yeah.
I think it would be interesting to see, even historically, if there's been any increases, declines, and maybe you wouldn't have that data right now because it's so new, to Judge Rhodes' point, but you might have it ongoing, right? And just to be able
Yeah,
to
no, we've been trying to track the 8.3 complaints precisely to see if there is something that we see along those lines. We don't have a lot of data yet because the rule, as you said, only came in last year, but okay, I will go back and see what data we have. I mean, just my sense is that the majority of the complaints we get come from clients. But let me check and see if my anecdotal belief is verified by the data.
Thanks, George. That would be really helpful.
Sure.
Anybody else have questions for George? I know it's a lot of information, and it's a lot of really important information that he presented to us. I don't see any other hands. So again, thank you, George, for being here today, for the slide deck, and for all the work that we just added to your plate.
It's don't worry, it's just to give a quick shout out. I reach out to the Mission Accountability and Advancement Division, which basically is our data source, and work with them to see what we can pull. So kudos
Well,
to
thank
them
them for
for
us as well,
being
please.
available.
Like the unsung data heroes somewhere.
Lisette's one of them.
Yes.
Oh, is Lizette one of them?
Yes.
Great, thank you, Lizette. Okay.
All right, thanks.
Great, thanks for being here, George. We'll see you next time, I'm guessing.
Yep, bye.
And in the process of shouting out Lizette, we move to agenda item 6.2, which is a presentation and discussion of the 2023 diversity report card and the inactive attorney survey. And Lizette is here to present us what I understand is some very interesting information.
Yes, hello, good morning, everyone. Thank you for having us here today. I'm not sure if you're able to.
Sorry, Lisette, to interrupt. Can I have Kim or Shannon, can you promote Ewing, who's I think I see in the attendee pool?
Yes, they've been promoted.
Oh, okay. Oh, I don't see them here.
It says they are rejoining.
Oh, okay, great. Thank you. Sorry, Lisette.
Oh, no worries. I think Ewing is here now too. Okay, I'm gonna go ahead and share my screen. And then let me know if you're able to see it once I start sharing. Okay. Is everyone ever able to see the screen?
Yes.
Yes, okay, perfect. So thank you again for having us today. I'm Lisette, a Senior Program Analyst in the Office of Research and Statistics, and we'll be going over a high-level overview of the 2023 Diversity Report Card. So just to give a brief overview, the Diversity Report Card should be published within the next 2 weeks. So today we just wanted to give an overview in the meantime and share with you the high-level overview. So the 2023 Diversity Report Card describes the diversity of California's 2023 attorney population and analyzes the changes in demographic representation since 2019. So we have that 5-year trends for all the demographics since 2019 when we first began collecting that data. We also explore the racial, ethnic, and gender patterns and the recent cohorts of admitted attorneys to the state bar. Some new features in this year's report include analyses on Latino and Asian subgroups among active attorneys, and then also detailed reporting on the intersection of race, ethnicity, and gender identity. So that's something that we haven't reported on before. And then also we include a summary of a forthcoming report on the diversity of inactive attorneys. And then finally, we also have a section that features just a description of the DEI leadership seal at the very end of the report. So moving on to our methodology. So we do have 2 data sources. One is the State Bar Attorney Census, which again is a voluntary survey administered during the annual licensing fee payment period through the online portal. And again, the survey was first issued in 2019 and it had questions on demographics, sector, workplace leadership, and climate. And since then, we've developed two versions of the survey. A short version which only contains the demographic questions and is administered annually, and then another more extended version again that includes all the other information that was first collected. And in 2023, where the report focuses on the short form version of the survey. And again, we also use the State Bar Admissions database to get more demographic information there. And then on the screen, you can see the demographic characteristics that we report throughout the our sections of the report. So moving on to our first section is the diversity of 2023 California licensed attorneys and the 5-year trend. So again, this page focuses on the diversity of 2023 licensed attorneys compared to the California adult population. And the analysis for each demographic characteristic has two charts, one that shows the percentages for 2023 and another that shows the 5-year trend. So here on the screen, we can see figure 1, which explores race ethnicity. And we can see on the left, in 2023, white people comprise nearly 2/3 of California attorneys, while only 38% of the state's population. And on the right, you can see that the same group has decreased since 2019, while the share of attorneys who are Asian and multiracial has increased. So just a brief overview of this section of the report. Again, all of the demographic characteristics are reported on this page, and we'll have the 2023 numbers and the 5-year trends. So moving on to the diversity trends among newly admitted attorneys. This page explores more information on our recent cohorts and just a brief overview of some of the findings on this page. We can see that figure 13 explores the intersection of race, ethnicity, and gender identity among newly admitted attorneys since 1990. And we can see that the share of men and women of color who comprise newly admitted attorneys since then has increased significantly. In 1990, both groups comprised of 9% and 8% of newly admitted attorneys, and in 2023, we can see that women of color comprised the largest group of newly admitted attorneys, so they're 33% in 2023. And then also going along with that, but just looking at the intersectional data, detailed race, ethnicity, and gender identity of those admitted to the state bar since 1990. We can see that since 1990, Asian and multiracial women have experienced the largest growth in representation. Asian women comprised only 2% of newly admitted attorneys in 1990, but 13% in 2023. And multiracial women comprised 1% in 1990, but 8% in 2023. So again, representing the largest growth since 1990 to now. And then moving on to our overview of the Inactive attorney report. This is something that is another report that we're hoping to publish soon. And just a brief overview of the profile. So again, we wanted to include more information on the screen here for inactive attorneys. So in California, only attorneys with active status can practice law, and attorneys can voluntarily transfer to inactive status at any time. On average, annually, 4,600 attorneys transition to inactive status annually. And in the study, we explored how that number has changed within the last 10 years, what the demographic characteristics of those transferring to inactive status look like, and then also who transferred and why they opt out to go inactive. So our first section here, really trying to get at who transfers to inactive status. So in this figure, we can see the intersectional detailed data for race, ethnicity, and gender identity of active attorneys and those 2023 transfers to inactive status. So in this figure, we can see that in 2023, white men and white women were the only groups of attorneys who were overrepresented compared to their share of active attorneys. And later on in our slides, we can see that our analysis suggests that retirement plans and age explain why white men are transferring to inactive status. And but for and that is due to retirement plans and age. However, our analysis doesn't explain that so much for white women who are also overrepresented of those transferring to inactive status. And then here in this figure shows the retirement plans among those 2023 transfers to inactive status, again, by the intersection of detailed race, ethnicity, and gender identity. In this chart, we can see that white men are transferring to inactive status due to retirement. For 70% of white men are transferring to inactive status due to retirement, and then white women are transferring to inactive status again at 55%. However, men and women attorneys of color, as you can see here, are less likely to transfer to inactive status for reasons not due to retirement. And you can see here, again, other groups that are transferring to inactive status, not due to retirement, Native Hawaiian and other Pacific Islander, and then also Middle Eastern and Asian attorneys, again, have higher percentages of reporting transferring to inactive status, not due to retirement. And then moving on to the average age of active attorneys and who transfer to inactive status by the intersection of race, ethnicity, and gender identity. We can see that attorneys who transfer to inactive status were older than active attorneys. So on average, active attorneys were 50 years of age, and then those transferring to inactive status were 61. So you can see here, white men are on average older than all the other groups, and also the totals, followed by Black men and all other men of color in their 50s. And then here, white women and white and Black women, again, are on average older than the rest of the attorneys transferring to inactive status, followed by Latino and multiracial women who are in their early 50s, and then Asian and Middle Eastern women who are shown to be in their 40s, and then the youngest transferring to inactive status are Native Hawaiian and other Pacific Islander women. So that is our overview for the diversity report card and the inactive report. And next steps, as Elizabeth mentioned early on this meeting, we will be working to revise both our short and extended versions of the attorney's census. And we'll be revising both versions based on current best practices and feedback the State Bar has received over the past few years. And again, we'll be working with some of you to review and hoping to get your feedback. So we look forward to that process as well. And that is it for our overview. If you have any questions, we're here to answer.
Thank you, Lizette, and you for this great presentation. I see that lots of members have comment. Shalak, we will start with you and then Angelica.
Yeah, thank you so much, Lizette. I personally always find this information really, really interesting and sobering. I guess my first question is if and when the diversity report card will be public. I'm not sure if it's published yet, if you plan to publish it, if some of the slides that you've shared will be part of that. For full disclosure, I teach a class on this that many people here I've tagged in, and I would love to have my students really dive into this, but I don't want to give them information that's not public. So that's part one, is very, very, personally beneficial, but also I think because I think it's helps to ground. So I'm wondering if one, there's anything that you can share on that, and then I have a second part question.
Yeah, so the report will be published within the next 2 weeks, so we hope to share that with you all soon. And then, yeah, so the report will be published in Folion again, like our previous 2022 diversity report card and other reports we published recently. So that report will also have interactive features where you can see again, like the 2023 trends, and then also the 5-year trends. And then also like I think we'll also be including data on county level, so that will also be interactive and we'll be publishing within the next 2 weeks. So we're really excited to share that with you.
Thank you. And then my second part is whether or not the state bar, I found that attrition information on, that dive into people leaving the profession, or let me say, going inactive, to be clearer with terms, and whether or not that was due to retirement, really thought-provoking at least, and it raised several questions for me. And I was wondering if the state bar had any plans to dive deeper into that reasoning and perhaps finding out some of that, and if not, if perhaps there's something COAF could do around finding out some of that and thinking about ways to prevent that type of attrition. So whether that goes to belonging metrics or inclusion metrics in the profession that may be impacting whether or not, particularly people of color and those intersections around women of color, whether or not there are interventions that perhaps we could recommend, for example, in the Leadership SEAL program to help stop some of that attrition in ways that might otherwise intersect with the state bar. So that's kind of a question for you. It's maybe really more of a comment towards Judges Rossi and Rhodes and Elizabeth. But to the extent you can answer whether or not you know of any plans to dive deeper into that inactive status, I think that would be really useful for us.
Yeah, I know, oh, go ahead, Ian.
I can take a stab. So it is our very first report in inactive status. So I think the first thing is to disseminate the information. I mean, to have a presentation today here is one of the very first steps. I would love to hear you guys' feedback on how we could disseminate such information to a wider audience. So that's one. Another thing is that we will have a full report. So a few slides you have seen today is just one part of that report. That report will also be shared to the committee in 2 weeks. So that's another thing we can do. So you will see more results in that report. About how we do things to prevent that, I have sort of two thoughts. One is the survey right now is just one-time survey, and we feel we have a lot of, as you said, maybe intervention related questions we could have asked. So that would be State Bar's next step, in addition to disseminate the information, but also to design something that we could act on. Right now, the current survey is more about, collecting information, but we should design and add some items about what actions we could take in the future survey. So that's my quick thought.
And can I just add, just to clarify clarify hopefully a little more. When attorneys submit the paperwork to go inactive, they are provided with a survey. And in that survey, we do ask questions about the reasons why they go inactive. I'm assuming because the report is not yet published, we did not get that detailed data. But Ewing, Lisette, will that information be included in the report?
Well, but again, you know, only knowing the reasons are still not actionable to some extent. So I still feel the survey has some way to
Right.
improve.
I'm not saying the
Yeah.
survey can't be improved. I'm just saying there is additional data that I think COAF members will find illuminating.
Yeah.
Yeah, thank you, Elizabeth. And awesome question. Shalak, Angelica, and then Novella.
I think this probably goes to what we were all just discussing of, you know, what the survey asks for, how people respond, because I assume that some folks who go inactive could actually be practicing law, just not in California. They might be barred in a different state, or be a professor. So I guess all I'm saying is I'm sort of just interested to see the full, and excited to see the full report, and see how, you know, if any of that information reflects that, you know, maybe folks are just, you know, maybe they did retire from California, but moved to a different state. And so are barred somewhere else.
Yeah, that's a good point, Angelica. Thank you. Novella.
Yeah, I really appreciate that data point about inactive status and the reason was included. And I think the visual of showing like inactive for retirement versus other reasons was illuminating. And for the, I guess, the sub reasons within the retirement versus not retirement, I think it could also, like, to the extent we have that information, it could be helpful to represent that in like a visual. I don't know the name of the graphs, but I think they like have circles and they get bigger depending on like how many responses use that one as an option. But I think that would be information that it sounds like we would want to have and could also help the public and perhaps inform what next steps we would want to take to respond to that attrition rate for women of color.
Okay.
Can you hear me now? Good. Thank you, Novella. Can COAF provide feedback to you all on the report card and the inactive survey? Is that something that we can do?
The both, yes, of course. I think the survey instrument of diversity report card, that's part of the work plan of
Yes.
COAF, right?
Yes.
Inactive, not yet, but we can add it in.
Great.
For the next year.
Thank you. Thank you. I mean, I think, you know, probably everyone here on COAF would thinks that this is something that we ought to be looking at. I mean, the fact that 33% of the new admittees are women of color is great. And then the question is, how do we keep them here? Because it doesn't do us any good to keep to increase the pipeline if we can't retain the folks in the profession the way that we want to. So let's do what we have to do to provide feedback to Yoon on this and make this part of our work plan. And Shalak moved to Shalak, you have your hand up. The record button is right over your hand, so so I couldn't tell if it was actually up. And then so Shalak, and then Yemi's hand I can see. Oh wait, or did you not, Shalak? You did.
Sorry. Yes, not to belabor the point, but a thought that just popped in my head is probably in 2019 or 20, the ABA Commission on Women, I think, released a a very interesting report, Left Out and Left Behind, which explored some reasons for female attrition from the profession, particularly women of color. And I'm raising that only that if you or others, you haven't had a chance to see it, it might inform some of those additional questions that might be added to the survey, or maybe prompts like that could be added when someone goes inactive to that question about why did you go inactive? There could be a couple of optional questions that are pulled from that report that might get to some of those inclusion and belonging metrics that we're seeing sort of in society are important for people remaining in a profession. Because yeah, I agree. I mean, I've been watching for the past few years that while the numbers of law students, particularly law students of color, have been increasing at the law school side, the numbers of those attorneys of color have been remaining stagnant for the past 20 years, which says that our issue in the profession is not necessarily getting people into the law school, it's getting them to remain in the profession. And so I think anything we can do around this is the important next step for COAF, for the state bar. And I think that report might be a very good one to help us illuminate questions that we might ask. And so again, I mean, not that anyone needs more work, but I really think some type of working group on attrition and inactive status would be really, really important. And not, again, that anyone needs more work, but happy to badger Elizabeth until that gets formed and to be part of that with whomever you all think is necessary. Because I will say also, on the law school side, the question I'm hearing most from prospective law students is, do you think I'll be actually able to stay in this profession long-term? Because that's what they're starting to hear about from their mentors. And so, you know, we need to be looking at that as well.
Great, thank you, Novella, and I can promise you that Michael and I and Elizabeth will figure out a way to get it on the work plan and do what we have to do to.
I think it's fine.
Great, Elizabeth thinks it's fine. And so that means we're good.
Yeah.
And so I do think that a subcommittee or whatever we
A
call it.
working group?
A
I would
working group,
like
thank
to
you.
ask for volunteers for a working group, so 2 members. If you want to, Shalak.
There's the, oh, I don't know who's.
Yemi and Tara both have their hands up.
I know, but I can't tell if they're having hands up.
They were commenting.
Oh, okay, well, I would love to be on that as well if no one else wants to do it. For the time that I'm here, and then someone else is gonna have to take my place, but.
Great.
But thank you. Thank you for that. Okay, Yemi and then Tara.
I was just wondering, and I may have missed that. Somebody did give me a quick call, but I was just wondering if we have comparable data from other states to contextualize the issue, to figure out if it's sort of profession-wise, and I note the ABA report, but if there are states that we know that folks typically may move to if they leave California, if there's just some way to contextualize the data more fulsomely. Excuse me.
It's my, to my knowledge, California is a leader in terms of collecting this type of data, especially the demographic data. I know that I've talked to other states where they've asked about how we collect the data, the categories that we've chosen and that sort of thing. So I know that the ABA does collect some data, but I do think in terms of kind of how rich the data that we have here and how rich the data that you've just seen is, I think California may be one of the only ones, if not the only one, that has this type of data.
Yeah, and I sit on several ABA committees and I get requests all the time from folks from other states saying, you know, can you tell me what California is collecting, because it seems like California is collecting the best data and the most data and has the best reporting on this. I just don't think anyone else. I know Oregon collects some data, but again, their sample size is very small and their demographics look a little different than ours. And so, but I know Michigan is looking to start collecting that data, and they actually asked me to hook them up with the state bar on this. So I think we're out in front on it, which of course we are, because you all are amazing. But I think that if we looked around, there probably wouldn't be very much out there besides what we have. But that's a good question, Yemi.
Just to follow up that,
Yeah.
it's a slightly less relevant, but is there similar attrition data for other professions? Like, are we seeing, like, post 2020, young African Americans deciding to start their own businesses rather than stay in corporate or whatever? So our engineers, are we seeing the same level of
That's a good question.
attrition in those professions too? I'm just wondering if there's a wider trend line, particularly since we've come through this dramatic season where folks moved away from being in office and being in work and looking more to entrepreneurial endeavors generally.
Yeah, that's
So
a great
maybe
question.
a blip.
I would say likely not. I would defer to my colleagues in MAD if they know, but I know that when we first were developing the diversity report card, we did try to look at other professions, to look at just diversity statistics for other professions, and could not find comparable data. So I think likely not, but I defer to Lisette Ewing.
Not that I have reviewed such reports, so I don't know. But I want to go back to that ABA report. We definitely, the next step we should definitely get some ideas from that report. Another thing is that, yes, California is definitely in the lead of collecting data. I recently had a presentation about the focus study 1 and Robinson report and the state board's actions on DEI initiatives at the National Organization of Bar Council. And during that presentation, I co-presented with George. During that presentation, we had some data collection. So about 15 jurisdictions said they have been collecting demographic data. But no jurisdiction said they have been doing anything in terms of addressing any gaps or disparities found in the data, or they published any report. So just give some numbers there.
Great, thank you, and thank you for making that presentation about Robinson and Farkas reports, which are both really important work that the State Bar has done. Tara, yes.
This is fantastic. I'm so glad that we are collecting this data and doing it in this way. I think it's very thoughtful. I have a question about in one of the previous reports we saw before this report, we saw a breakdown of lawyers who are practicing, let's say, in government or at a law firm or private practice on their own, et cetera. Is there a way to break down this report and the attrition data based on that, so we can see exactly what needs to be done at the various levels? Because I can think of, in particular for women or women of color, and the correspondence of the ABA report that has also been raised, which I think is fantastic. I've read through that as well, that there are some things that perhaps law firms or government or other entities can do to support these lawyers and lower the attrition. But being able to see that breakdown, I think, would be incredibly helpful.
Yeah, taking notes right now. I agree that's very important, but it's not there yet. It's not in the current survey.
But that's a great add, Tara. Thank you, because it would be nice to know where. I mean, we know there are more women of color in public sector, in nonprofits, but it would be interesting to see if that's who's leaving, especially for Asian women, since that number is so high. It would be interesting to see where they're coming from. Yeah, that's a great add. Thanks, Tara. Okay, any other questions for our brilliant statisticians who are here today? Okay, I don't see any. Thank you again, both of you for being here. This is really, again, great work, and so thought-provoking that we created a working group on it already. So thank you all for all of that, and we look forward to working with the folks is it MAD? I like that.
Yeah.
MAD, yeah.
I like that. I like it.
Not MAD.
I like it. We look forward to working with all of you on this data. Again, it's really groundbreaking, and thank you for putting it all together for us. And we will, of course, send out the attorney, the diversity report card when it comes out. We will pass that on to all of our colleagues. So thank you for that.
Sounds good. Thank you.
Thank you.
Thanks. Okay, so we're gonna skip item 6.3 because Natalie is very busy today. We're gonna push Natalie to the and later in our agenda. So we will skip to 6.4, which I think Danielle is here. There's Danielle. Hi, Danielle. Danielle is going to give us an update on our Leadership Seal program.
Perfect. Yes, I will share my screen. I have so many monitors. Let me make sure I'm sharing the right one. Alrighty, hopefully you all can see the slides. Is that correct?
Yes. Yes.
Thank you. So I am here today to give you an update on the DEI Leadership Seal program, and also, spoiler, we'll follow this up with an update on the Diversity Summit. So you'll hear from me for the next 2 items. Great. All right, we will get underway. So for the Diversity Leadership Seal program, I want to start with a brief program overview for some newer members, or if it's just helpful to have a refresher. The DEI Leadership Seal program was launched by the State Bar in January of last year, and it's a program that recognizes legal employers who commit to and implement DEI best practices, or as we call them, action items, in their workplace. And so some of those action items include things like collecting data on employee demographics, creating and publicly sharing a DEI strat plan, comparing attorney hire demographics to the California attorney population, creating and publicly sharing a DEI statement, and the like. There's others on conducting stay and exit interviews with staff and having questions related to DEI in those interviews, conducting a survey of staff as it relates to DEI in the workplace, and so forth. There's a list of 10 of them. And employers can participate in this program as either a committed employer or a SEAL recipient based on whether they have actually implemented these action items. So an employer needs to have implemented at least 5 action items to be considered a SEAL recipient, and they can be a bronze, silver, or gold tier recipient based on the number of action items implemented. So those that implement at least 5 are bronze, those that implement at least 7 are silver, and then those that implement at least 9 are gold tier recipients. And in our first cohort that we launched last year, we had 34 SEAL recipients and 43 committed employers. So we were super excited about that last year and have been working with them throughout the year as they continue to implement the action items and help us with outreach for this program. So what we've been doing since the meeting in December and the last update we provided to COAF, we launched applications for the second cohort this January. We're anticipating that will continue to be an annual application cycle. And those applications are due back March 29th. So just in a few weeks, we'll have that new batch of applications to review. We are currently reviewing attestation and tier advancement documents from the first cohort employers. And what those are current SEAL recipients. We asked them to submit a quick attestation form that attests that they still have those action items implemented, and we can continue to list them as SEAL recipients because they still have at least 5 of those action items implemented in their workplace. And then for both currently committed employers who have implemented 5 or more and want to bump up to the SEAL recipient bucket, there's a tier advancement form that we had them fill out so they could submit those materials. And also current leadership SEAL recipients, if they implement additional action items and want to also move up tiers from bronze to silver, silver to gold, there was an opportunity for them to submit those materials for State Bar staff to review and ensure they meet our implementation and documentation requirements. So we had one of those opportunities due in February. So staff are continuing to review those materials and make sure we have what we need from folks. We are also continuing to evaluate strategies to make this program cost neutral, which is something that was requested of State Bar staff by the State Bar Board of Trustees. And as always, continuing to brainstorm opportunities to offer additional benefits to employers and conduct outreach, get the word out there about this program, generate excitement, and continue to just get the word out there. And one thing specifically that we've done around outreach recently is we are collecting testimonial language from current seal recipients so that we can share those on social media. So our communications staff has been really helpful in drafting some testimonial graphic templates. And then once we get that language in, we'll plop that into the template and be able to share those on LinkedIn and the like, both for the State Bar and for the seal recipient organizations can share those materials themselves. As far as next steps for the leadership seal in the next month, as I mentioned, the team will begin to review the cohorts 2 applications. Those are due at the end of March, so early April. That'll be a heavy lift in our office. And then also we would like to reconvene the working group to help us with these conversations around outreach, cost neutrality, and future changes to the action items. And it would be really helpful if we could get one additional member for this working group, because Tristan had been helping us with this, but is currently out of commission a bit with some health.
You're on it. We can have one more. Okay. Great.
So that's the extent of the update on the leadership seal. So happy to take any questions, hear any feedback at this time.
You're on my list, but maybe not. Okay. Thank you, Danielle. To remind folks, the working group for the leadership seal, is it Michael and Yemi? Was it Michael, Yemi, and Tristan?
Yes.
It was? Okay. Yeah, and for folks who don't know, Tristan is having some medical stuff and probably won't be able to help out for a little bit longer. So is there somebody else that wants to volunteer to be on this working group with Michael and Yemi? I can't tell if anybody's got their hand up because it's a weird format.
Nobody has their hands up.
Okay.
And you can think about it and we
You
can
wanna
reach
think
out
about
to
it.
later.
Yeah. Think about it, reach out to Elizabeth or Danielle on that. Thank you, Danielle, for that presentation. Does anybody have questions for Danielle about the leadership seal? I think that's Novella.
This is just a logistical question. Is there a way to view the applications on the website without starting one to apply for it?
So we were just actually having a conversation about that internally earlier this week, because right now I think there is not. We took down the PDF version because we want folks to submit via DocuSign, but realized that is a challenge if folks just want to review the materials. So that's something that we'll work with the communications team to get onto the website, because right now it is not publicly available in that format.
Thanks.
Great question, Novella. Okay, anybody else have a question for Danielle about the leadership seal before she moves on to the diversity summit? All right, I think you're good to go, Danielle, for diversity summit.
Perfect. Yeah, I will not introduce myself again. This is item 6.5 though on the diversity summit. And wanted to provide a quick overview. We held a diversity summit remotely in December of last year, right after the last COAF meeting. So wanted to let you know how that went. The agenda for that included a keynote address from Professor Rachel Moran, on students for fair admissions versus Harvard, and I followed up with a question and answer session around that case and what it meant or didn't mean for employers as they think about DEI in the workplace. And then we also had a great panel discussion around strategies to build and increase support for advancing DEI among organization leadership and employees. And we had 85 non-State Bar staff attendees. With staff, it was about 102 maybe attendees across the legal field, which was great to see. And in terms of gathering feedback, we did a short survey, and those that completed the survey found the webinar, or the summit, to be generally positive. There was a desire for more specific strategies and concrete recommendations about implementing DEI in the workplace. I think there would be an appetite to, for example, talk about how employers might be able to implement some of the DEI Leadership Seal program action items and other similar strategies. the panel had a really great discussion, but there was only so much time allotted. And so I think it was really interesting to hear, but folks wanted a little bit more like in the weeds, nuts and bolts. How do I do this in my workplace? And so building off of that, we are planning to hold 2 diversity summits in 2024, ideally one in person and one virtual, and would like to form a working group to assist with planning those as well. And I think Elizabeth and I would like 2 members for this working group if possible. Happy to take volunteers now or think on it and volunteer later. And then again, that's the last slide on this, so happy to take any questions or comments. If those that were at the summit have any feedback, be happy to hear that too.
I was there. It was phenomenal, and thank you, Shalak, again for moderating. If you, I guess we didn't. Did we record it?
No.
No, we didn't record it. Shalak did a master class in moderating. So for those who got to see it, she really did do a phenomenal job. And it was really informative, really interesting. And I think the numbers of people who come keep increasing. So, you know, it's great. I've moderated it before and watched it many times, and it keeps getting better. So thank you all for putting that on. Shalak, I see your hand.
Yeah, first of all, that's very kind, but it feels very untrue. More to the point, I wanted to say that the feedback I heard from the panelists was similar, Danielle, like trying to figure out how could they share more about like, here's what we're actually doing. And I think at the same time, they were also like, we are not the experts. We're trying things out. Some of it works, some of it doesn't. Which if I'm recalling correctly from a conversation that was held around now I can't remember if it was at the COAF meeting in December or in a working group about innovative practices, but in either one, I feel like part of the conversation was about having a space to be honest about here's what didn't work as much as here's what works, right? And so that's just something that I would throw out there for the next summit, that it might be helpful for people to hear sort of honestly, we've been trying to do this for 2 years, 5 years, 10 years. Here's what hasn't worked for us and our takeaways from that, as much as here's how we've been so successful, you know, that might be helpful.
Yeah, absolutely. That I believe that was in one of the DEI Innovative Practices Working Group meetings, but that was something that stood out to me as well. And just to say, I think the praise on your moderating is absolutely deserved. You had a very tight time frame to get a lot done,
Yes.
and it went very, very smoothly, given the time constraints. So no, I definitely second the high praise.
You're not going to get away from that. Good try.
Yeah.
Okay, other questions about that? If you're interested in volunteering for the Diversity Summit and helping out on the next 2, please reach out to Elizabeth. And thank you, Danielle, for that presentation as well. And it was a great summit.
This is Tara. I'm happy to help with that summit. Elizabeth, if you want to put my name.
Great, thank you, Tara. Okay, we're moving to 6.6 on our agenda, and it looks like 6.6 is 6.9 is all Elizabeth. So we're going to start with an update on the early pipeline to the profession outreach materials.
Right, so we do have a working group comprised for this. However, we have not yet had a chance to meet. So we will convene the working group between now and our next meeting. And I think our focus will be on looking at the brochure and also perhaps thinking through whether we want to do videos and how we might move forward with that.
Okay.
So that is.
Can you remind me who's on that working group?
Sure.
If you
I
know.
believe you are.
Oh, fantastic.
As well as Yemi.
Okay, fantastic.
So I will be in touch with you shortly.
Okay. I think we lost Yemi.
Okay.
Maybe she'll come in.
Okay.
And then update on research and on innovative DEI practices, which we just touched on briefly.
Yeah, so we are continuing research on this item. Shalak and Tristan are this working group, but with Tristan's unavailability, we would like to ask for another working group member. So if anybody would like to volunteer for this, please let us know, and we will get you into the fold quickly.
I think Novella's got her hand.
Okay.
Novella, just so you know, I don't know if you can see this, but the name tag basically covers you, where you're sitting. So I could see the top of your hand, but we really can't, like, so put your hand higher. But I saw it peeking over your name
Great.
tag.
Thank you, Novella. So we'll be in touch shortly on that.
All right, and then moving on to our presentation on the Imposter Syndrome Toolbox.
Yes. So Shannon, could you help me with the presentation? Sharing
Yes.
the PowerPoint?
Yes, one moment. I'll pull it up.
Great.
Thank you, Shannon.
Of course.
So this is a presentation on our Overcoming Imposter Syndrome Toolkit. One of our staff, Alexa Montalvo, worked on this with the working group. And fortunately for her, she is on vacation. So I am going to present on her behalf.
Okay. We can see that, Shannon. Thank you.
Can you put it in presentation mode? Slideshow?
Yeah.
Thank you.
Thank you.
Great. Next slide, please. Okay, so we'll just go through the background for some of our newer members and what we did, and then we have a screenshot of the toolkit to show you. So next slide. So for those of you who may not know about imposter syndrome, it is a term for high-achieving individuals who, despite their objective successes, cannot internalize their success, which leads to feelings of self-doubt related to one's intellect, skills, and accomplishment. And it does, it does impact attorneys of color in particular. So efforts to combat imposter syndrome in the profession were really driven by our former COAF member, former COAF chair, Ryan Harrison, and the State Bar's strategic plan to support retention, development, and advancement of a diverse legal profession, with a focus on preventative measures to address disproportionate complaint and discipline rates. So that led to the creation of a COAF working group a couple years ago, and that working group is made up of our former chair, Ryan Harrison, Shalak, and Stephanie Santoro. Next slide. So the goal was to create a resource on the State Bar's webpage to address and normalize imposter syndrome in the profession. Next slide. And so staff, we worked with our colleagues in the Office of Professional Competence, as well as with the working group to research academic journals and articles and other media that looked at imposter syndrome, specifically in the legal profession. We were able to get some really good technical assistance from some experts on imposter syndrome in the profession in Oregon. And they provided us guidance and resources, including a worksheet that we adapted that is now in the toolkit. And so, next slide, please. And so this is a screenshot on the right-hand side of our toolkit. And Ryan very graciously recorded a video talking about imposter syndrome, which I think has actually received quite a few hits. So that's very exciting. And so the toolkit also includes articles in academic journals, links to a podcast and a TED lesson, as well as Ryan's testimonial. As I mentioned, there is a worksheet that we've included to help people kind of think through their feelings and thoughts. And we hope that that is kind of a springboard for more discussion with attorneys and law students at law schools, at the places of employment. I know that in our office, Alexa previewed this for our staff earlier this week, and we are going to try to do like a brown bag kind of discussion after folks have had a chance to take a look at the worksheet, because I think you know, it's something that a lot of folks face and haven't talked about or haven't had the words to talk about. So we're really excited to make this available. And so, yeah, I think that is, the last slide is just a question slide. So if there are any questions, I'm happy to take them now.
Elizabeth, how are we letting people know about this awesome resource? Are we getting it out to law schools?
We've only really just put it out on social media. But we could be more directive, and actually I think that's a great suggestion. We can share it with our colleagues at admissions to share it with law schools.
I mean, I think that would be great. I think it would be great if there was a link on the admissions page to it. I'm just thinking about the number of law students who might be looking at the admissions page and then, you know, being able to see a link to that, given all the other stuff that we try to do to help law students. That would be great. Shalak has her hand up. And then Novella.
Yeah, I was going to say, I think this was one of the resources. I had the dubious honor of representing the state bar at the California Law Pathways Summit, which is geared towards prospective students, right? So community college primarily, and some undergraduate. And I think this is one of the resources that we highlighted to them. And the response to that was very, very strong. I think many will be going to review that in the coming months or years. So just thinking about even that broader pipeline of places that it could be shared with, and perhaps linked to in other prospective materials that might be given. But yeah, I agree with putting it on those, on the application or admissions sites as well.
And thank you by the way, for representing us there. I appreciated it. Specifically, I appreciated it. Thank you. Novella.
Thanks. Yeah, I was wondering if we were planning to add anything to the resources section. I attended the Bay Area Women's Lawyers Retreat a couple weeks ago, and Judge Wiley interviewed Associate Justice Evans, and one of the things that they talked about was imposter syndrome. And I thought Justice Evans had like really insightful answers and perspectives about like her experience with that and how she tries to counter it.
Oh, that's great.
Was that recorded, Novella? Sorry.
Yeah, do you know if that was recorded?
I don't
know if it was recorded.
I don't think they recorded any of the sessions at the Baller Retreat.
Okay, so I mean,
but I know Justice Evans
and she
as well.
used to be the director of our office.
Yeah.
So we can reach out to her to see if she might want to do a little video for us.
Yeah, that would be great. I think she probably would. She's incredibly generous with her time and.
Thank you, Novella.
That's a great idea, Novella. Thank you for that. And I haven't seen Ryan's video, but I am sure that it is compelling, as I have had the honor of knowing Ryan for the last 5 years. I'm sure that it is compelling. So for those who haven't had a chance to look at it yet, we should all do that. This was one of Ryan's brilliant ideas, and it will make a difference, I'm sure. Okay, anything else? Do we need another person for this? So if you're for this working group, are we good?
No, we're done. The
we're
working
done.
group is sunset.
Okay, we have sunsetted it. Okay, but we are still taking ideas.
Yes.
Okay, so if you have ideas for things to add to the toolkit, reach out to Elizabeth on that. Okay, moving on to 6.9, the implicit bias online MCLE module.
So we have begun working on reviewing and updating the current implicit bias online MCLE module, which is available on the State Bar's e-learning platform. That e-learning platform is available to all attorneys through my State Bar profile. And so our prior module actually, and I may be misremembering, but I believe our latest statistics on it, over 20,000 attorneys had viewed it. And so that's really great. And so we've got a lot of really good feedback from those attorneys. And so we are working with our same subject matter expert, Catrice Monson, and her company Groupfully to review the content and to make updates. We are also transitioning to, I don't know if it's a new platform, but it is a new way to view it that is more friendly to adult learning. So hopefully that will kind of enhance the user experience. And so I know that our prior working group was Angelica and Novella. And so if you both are still willing and available, we would like to send to you the transcript for review in the next several months. And I see heads nodding, so thank you both.
Great, thank you. Elizabeth, any questions about this for Elizabeth? Another brilliant idea that came out of the COAF. Thank you, Novella and Angelica, for continuing your work on that. Okay, item 6.10 on our agenda is discussion of additional DEI initiatives. I know we just came up with one new thing to add to our or to continue one of our work plan ideas when we're talking about the inactive status. But are there any other ideas that folks have right now that they want to talk about for other initiatives that we can be working on? I know I'm putting everyone on the spot right now. We have quite a bit on our work plan, but this is a dedicated group of individuals who gets stuff done. So if you have thoughts, please let me know. Not seeing any, you don't have to think about it. If you come up with anything, you can always reach out to Elizabeth and Michael and I.
So for item 6.11,
Yes.
Raul and I just conferred, and we thought it might not be a bad idea to add an active attorney to the work plan and have a vote. So if I may share my screen.
Mm-hmm.
So this is the work plan that COAF approved in December. And this is where the attorney census is. And then I just added for your review, review an active attorney survey report and provide feedback and recommendations as appropriate.
Great. Anybody want to wordsmith this? Or is everyone okay with seeing nobody wanting to wordsmith this? We need to take a vote, correct? To add this part to our work plan?
Yes.
It's broad enough to include feedback and recommendations on the survey and feedback and recommendations on potential intervention items.
feedback and recommendations, period. So it's open-ended.
I'm fine with it.
If you would like, we could be more specific.
I don't think we need to be more specific. I just want to make sure that that's what we've, that's what we're contemplating.
I think it is. Yes.
I move to add this to our work plan under goal 2.
Okay. Okay, I'm gonna stop sharing screen because I need to go to another document to record our vote. So
okay. Do we need a second on that though?
Yes.
Okay.
This is Tara, I second.
And Tara seconded. Thank you.
Great. I'll take the roll now.
Thank you.
Adebo Mary? Absent. Coleman?
Yes.
Davis,
Yes.
Hill, absent. Higgins, absent. Richards,
Yes.
Salceda,
Yes.
Santoro, absent. Rhodes,
Yes.
Rosie.
Yes,
Motion carries.
great. Great, thank you all. And this is a great addition to our COAF work plan. And do we want to review that a little bit? So our Board of Trustee liaison, Sarah Good, is with us. And it appears that this will be taken up at the Board of Trustees meeting later this month. Is that correct, Sarah?
Yeah, the board will be approving sub-entity work plans, including COAFs at next week's meeting. So I will get this updated version to my colleagues working on that agenda item.
Great. Okay, and do we need to review it one more time, or we reviewed it in December, do we need to see it again?
No, we just voted on it too.
Okay, good,
Yeah.
good, all right.
Yeah.
Okay, so we are slightly ahead of schedule, which,
So I think we should take a little bit extended lunch because we do have some scheduled presentations
Right.
after lunch.
okay, yeah, Raul, you're good to come back at 1?
Sure.
And then we have, I know Natalie is later. And let me just check in, because we're slightly ahead of schedule. Judge Dulcich, are you with us?
I am.
You are so incredibly gracious with your time at every one of our COAF meetings, and we always put you last on the agenda. And so if you would like to give your presentation now, so that, I mean, you are welcome to stay, and it is always an honor to have you here. And again, you are so gracious with your time, but if you would like to do yours now, because it is a Friday and you know, you might have other things you'd like to do this afternoon.
I'd be glad to.
Okay.
I can come back, or I'd be glad to now.
Well, we're 15 minutes out of schedule, and we had an hour break, so I can't imagine you have 15 minutes of judicial council stuff to share. So
No, I don't.
okay.
Actually, my report is pretty brief, and as I listened to you all, I thought of other things, and that's what I try to do as I monitor the meetings, like, you know, what you all would be interested that our Providing Access and Fairness Committee is also working on at the same time. I kept telling you all that the Racial Justice Toolkit was coming out, and it has indeed come out.
Okay.
I have a link, but I'm no good at sharing it, so I'm going to send Elizabeth a list of all of the links that I'm talking about. I don't know if I can share my screen, but I'm certainly going to try.
There you are.
Oh.
So
Oh,
that's our
lovely.
Racial Justice Toolkit. And this is something that, you know, we worked long and hard on. It's a compilation of resources for bench officers, trial court leadership, and court staff to find guidance and a launching point to incorporate racial diversity, equity, and inclusion into their court operations, to train and educate staff on issues related to bias, develop and sustain a diverse workforce, build effective community partnerships, and increase public trust. So it functions as an online hub where users can go to locate empirical studies, practice guides, and third-party affiliate links to local nonprofit organizations and accredited educational institutions that are already engaged in racial justice initiatives in their local communities. And it will be continuously updated as new information, data, reports, and resources become available over time. So the users of our site will be able to submit feedback and or suggestions for content to the working group via the Access and Fairness Committee email, which is regularly monitored by our Judicial Council staff. And if you have any questions, or if you want to suggest content, I will send to Elizabeth the Access and Fairness Committee email. So that was our Racial Justice Toolkit. We're very excited. It has a lot of information, not only for our judicial officers, but for our staff. And it's just a very helpful resource. I wanted to touch on something that I heard at our last meeting. Someone, maybe it was Tristan, mentioned an issue with forms and gender identification. So I followed up on that. I know that we've been working on that. So I just wanted to touch base on that. In 2019, the Ad Hoc Gender Identification and Judicial Council Forms Working Group recommended best practices when drafting Judicial Council forms. And that included, our first practice was to ask a gender identification question only when it is absolutely necessary to effectuate the purpose of the form. If it's not necessary, we'll remove it. And the best practice 2 was, if a gender identification question is required, it should be 1, legally compliant, 2, request information in a clear and respectful manner, and 3, elicit data that satisfies the needs of the form consumer. So if practitioners notice areas that a current Judicial Council form could be improved, my recommendation is that you identify the subject area where the form is being used, criminal, civil, family, etc., and then email a suggestion to the appropriate advisory committee with a specific form number and your request. These forms are updated constantly, so I'll give Elizabeth the email address for that, not for the advisory body contact information. Then I heard you all discussing your demographic data, and I know you were talking about more about inactive and your curiosity, but so this morning I was on a meeting with the Judicial Council because I'm a member of the council as well, and our annual report to the legislature was submitted on the release of demographic data on California justices and judges. And yearly we get an email asking us, to answer the questions so that they can compile this demographic data. And it's voluntary. So that's how accurate it is. But it was interesting, this year's report, as of December 31st, 2023, responding female judicial officers constitute 41.2% of judicial officers across all court levels, which is a 1% point increase over the prior year and an increase of more than 14 percentage points since 2006. And I'll mention I became a judge in 2007. 2006 is the first year we had this process started. The bench has also continued to be more racially and ethnically diverse. The proportion of responding white judicial officers has declined by more than 9 percentage points since 2006. The percentage of responding Asian, Black, and Hispanic judicial officers has doubled over that same time period. This data is also available on the California Courts state website, and I'll send a link for that to Elizabeth. But it just tied into what you all have been talking about. And I heard somebody talk about teaching and using this information. There's great information on our court website on all of this. So that was the extent of my report, unless you all have any questions.
Any questions for Judge Dolchitz? I don't think so. I really appreciate you. Again, I said you were very generous with your time, and you're always here. You always stay the entire time. And I really appreciate you listening and taking back the info and reporting back. I will make sure that Tristan knows that you reported back on the gender identification part for the Judicial Council forms as well. I know that Tristan will really appreciate that. Any other questions for Judge before we break? Great. Thank you again so much. You're welcome to stay if you'd like to come back after lunch.
Oh.
But please don't feel like you have to if I appreciate you giving your report early. Okay, it seems like now is a great time to stop, and we'll reconvene at 1 with Raul, who's going to give our annual Bagley-Keene and Prop 209 presentation, which I know I never tire of seeing. And I've learned and I'm reminded every time about what Prop 209 and Bagley-Keene require. So we'll break and then come back at 1. Thanks, everyone.
Thank you.
Our COAF meeting. We have next up on our agenda Raul is here, and Raul is going to do a presentation on Bagley-Keene and Prop 209 for us.
Hello, everyone. My name is Raul Duran, Assistant General Counsel in the State Bar's Office of General Counsel. We're presenting today on first on Prop 209, and then I'll jump right into a presentation on Bagley-Keene. So let me just share my screen. And then just for clarity's sake, the Prop 209 presentation is focused on just that, Prop 209, not sort of federal anti-discrimination law, including what Supreme Court may have recently decided. This is a focus on Prop 209. All right. And so, you know, the Prop 209 limits California government agencies' ability to consider race in other categories in hiring, contracting, and education. We think this training is important to COAF because as a public agency, the State Bar, it's subject to 209. It's important to keep these limitations in mind when considering various initiatives. So Prop 209 was enacted by California voters in 1996. It limits California government agencies' abilities to pursue affirmative action type policies. Prop 209 is codified at Article 1, Section 31 of the California Constitution. In relevant part, it states, the state shall not discriminate against or grant preferential treatment to any individual or group on the basis of race, sex, color, ethnicity, or national origin in the operation of public employment, public education, or public contracting. Proposition 209 is only implicated when the state government is operating public employment, public education, or public contracting. In practice, that means that Prop 209 is not necessarily implicated in all of COAF activities. However, it may be relevant when considering policies and practices typical of state agencies. Prop 209 issues have most often been relevant to COAF in the context of public employment. For example, it comes up in how we decide who to contract with. In public hiring, Proposition 209 prohibits discrimination against or preferential treatment of anyone on the basis of race, sex, color, ethnicity, or national origin. For Prop 209 purposes, to discriminate means, quote, to make distinctions in treatment, show partiality, or prejudice against a particular candidate or group of candidates. Preferential treatment means giving preference, which is a giving of priority or advantage to one person or group of persons over others. So Prop 209 applies to differential treatment of both members of a majority group and members of underrepresented groups. So there was an opinion by the California Supreme Court that recognized that the voters' intent in passing Prop 209 included reducing reverse discrimination based on either race or gender. Unlike the equal protection clauses of the federal and California constitutions, Prop 209 absolutely prohibits race-based discrimination and preferential treatment. Discrimination and preferential treatment cannot be justified even by a compelling government interest, as it can be in certain equal protection contexts. The courts recognize a distinction between impermissible diversity activities that advantage one group over another and permissible activities that aim to broaden access for all. So this high voltage case I've cited already, it's an important Supreme Court case interpreting Prop 209. In that case, the court struck down rules requiring city contractors to either meet a quota for use of minority and women-owned contractors, or to provide such subcontractors with special notice and procedural rights in the bidding process. The court also recognized that outreach designed to broaden recruitment of public employment is permissible. Plainly, the voters intended to preserve outreach efforts to disseminate information about public employment, not predicated on an impermissible classification. So this Connerly decision, there was further guidance given regarding the distinction between impermissible discrimination and preference versus permissible outreach. So there, the court provided further clarification and that affirmative action programs imposing specific goals and timelines for women or members of minority groups are considered impermissible, as are outreach efforts that provide special notice or other benefits only to certain applicants based on race, sex, color, ethnicity, or national origin. However, outreach efforts designed to broaden the pool of applicants are permissible. So a competitor does not have a constitutionally recognizable interest in limiting the pool of potential applicants with whom he or she must compete. Therefore, outreach or recruitment efforts which are designed to broaden the pool of potential applicants without reliance on impermissible race or gender classification are not constitutionally forbidden. So as an example of something that is considered permissible would be research and analysis regarding employment of underrepresented groups. So I'm not going to read all these bullets, but this is an example of sort of our, like the diversity report, for example, is something that's research and analysis of these categories that doesn't run afoul of Prop 2. So race-neutral policies promoting fairness and diversity may be permissible so long as criteria are not used as a proxy for race. This sort of came from this American Civil Rights versus Berkeley Unified School District opinion. I won't get too much into it, but basically, whether there's a question of whether or not sort of efforts, there's like a proxy for race being used, is a pretty fact-specific analysis. And if this question comes up, it's likely something that will be evaluated by OGC. But I guess that sort of in practice, impermissible activities to know about, that you can't base any hiring policy or decision on race, sex, color, ethnicity, or national origin. Prohibited conduct includes numerical quotas and goal setting. The prohibition applies not just to policy, but to individual decision making. For example, in the event that two equally qualified candidates are competing for a position, race, sex, color, ethnicity, or national origin cannot be used as a tie-breaking factor. Also, providing special notice or information relevant to hiring or recruiting only to members of certain enumerated categories that is not also made available to all potential candidates is also prohibited. What's also permissible is reopening positions or otherwise adjusting hiring procedures for the purpose of obtaining more candidates from any enumerated category, and providing incentives to managers for hiring individuals from any enumerated category. However, what is clearly permissible is outreach to increase the applicant pool, such as posting job opportunities with minority bar associations and other minority groups, provided the information shared is also made available more broadly. Participating in diversity and minority job fairs, provided that such fairs do not exclude participants on the basis of enumerated characteristics, and provided the state bar also participates in job fairs aimed at broader populations. So targeting outreach to underrepresented schools and geographic areas that are underrepresented in the applicant pool is permissible, as is advertising and distributing the State Bar's mission and its diversity policies and activities, including COAF's work, and using diverse hiring and interview panels. Also eliminating barriers to hiring, including job criteria that may disproportionately impact underrepresented groups while having no or limited relevance to job performance. Creating hiring guidelines and interview questions that value diverse skills and experiences, so long as the criteria are relevant to the position. For example, foreign language ability, demonstrated commitment to valuing diversity, such as experience, increasing access to the legal system or reserved groups, experience working in diverse workplaces or serving diverse populations, and demonstrated resilience in the face of adversity. Additional activities. Activities and programs to reduce unconscious bias and in-group favoritism, including training, monitoring, and analysis of female and minority involvement and success in recruiting and hiring, and consistent with Title VII of the Civil Rights Act of 1964 and the California Fair Employment and Housing Act, ensuring a discrimination-free workplace in order to promote retention of a diverse staff. So that's the Prop 209 presentation. Are there any questions? Seeing none, I'll move right into Bagley-Keene. So the State Bar is subject to Bagley-Keene. It was made expressly subject to it in 2016 with this addition to the State Bar Act and Business Professions Code 6026.7. although it's not subject to Bagley-Keene. Sorry, the Judicial Nomination Evaluation Commission and State Bar Court are not subject to it. Some of you may have heard of the Brown Act that governs city administrations. This is the Bagley-Keene is the equivalent for the California agencies. So I won't read this lengthy paragraph, but the purpose of Bagley-Keene is to do the public's business in public, give the public notice and an opportunity to participate in meetings. And it's important to know that courts and the California Attorney General usually construe Bagley-Keene provisions broadly in favor of greater public access. So what bodies are covered by Bagley-Keene? So every state board, commission, or similar multi-member body created by statute or executive order are subject to Bagley-Keene. So the state bar's board of trustees is created by statute. So under that first bullet there, that's why they're subject to Bagley-Keene. But in addition, boards, commissions, committees, or multi-member bodies that exercise authority delegated by a state body, and advisory boards, advisory committees, subcommittees, advisory commissions, or similar multi-member bodies of 3 or more persons created by formal action of a state body or member thereof. So I'll get into a bit more of that later, but this is part of what brings in these second and third bullets are what bring in most of the subcommittees and the other committees and commissions of the state body. And official representatives of state bodies serving on other boards or commissions that are supported in whole or in part by funds provided by the state body. So the question about whether or not a subcommittee is subject to Bagley-Keene can sometimes be unclear, but the criteria is usually based on one of 2 options. So a subcommittee is subject to Bagley-Keene if either they exercise authority delegated to it by the board or other state body, or it is formally created and consists of 3 or more persons. So informally created subcommittees are not subject to Bagley-Keene, provided they do not consist of a majority of members of another state body and do not exercise any authority or act on behalf of any other state body. So I guess the question then is, what is a formally created subcommittee? Again, given the broad construction of Bagley-Keene, what's considered formal action should be interpreted broadly. So unless the commission or committee is created by staff or an individual board member, independent of the body's authorization or desires, it should be viewed as formally created. If the chair of the state body acting in his official capacity creates the committee or commission, it will likely be considered formally created. But generally speaking, the following are not considered to be formally created. Those are committees created solely by staff or committees formed by volunteers outside of a formal meeting. So I think that's sort of the guiding principle for us is if it's created by staff, then it's not formally created and not subject to Bagley-Keene. So Bagley-Keene's requirements apply to meetings. So it's important to understand what constitutes a meeting for Bagley-Keene purposes. Under Bagley-Keene, a meeting is defined as any congregation of a majority of the members of a body at the same time and place to hear, discuss, or deliberate upon any item within the jurisdiction of the body. So if there is a meeting, it's subject to certain notice requirements. The general rule is 10 days notice. We do that by posting the agenda on the State Bar website. And the notice must state the date, time, and location of the meeting. The notice shall include contact persons for questions, and only items on an agenda can be discussed unless a late addition is justified with the required finding made. And I'll explain what that finding is in a bit. The meetings must be ADA compliant. There must be an opportunity for public comment, and though there's certain exceptions for special and emergency meetings. So the general rule is you can't discuss items not on the agenda. However, if a meeting has already been noticed and the meeting sort of is occurring, there's an exception if 2/3 of the body makes a finding at the meeting that there exists immediate need to take action that came to the attention of the body subsequent to the posting of the agenda. So only if that finding is made can you then add something and make sort of discussion on a topic that wasn't on the agenda. Another thing to know about meetings under Bagley-Keene is that materials distributed at the meeting are generally considered public records unless an exception is available. So for OGC purposes, we typically consider, the available exemptions under the Public Records Act to decide whether or not a record, would be exempt. But otherwise, the general rule is such materials are considered public records. You don't have to post those materials with the agendas, but they must be made available if requested. And records must be available at the meeting if prepared by the State Bar or after the meeting if prepared by a third party. So, a meeting, it's under Bagley-Keene, it's not strictly, sort of a gathering in one place of individuals. It sort of has a broad interpretation. And so it doesn't need to occur in one place. It can be a series of communications of any kind, directly or through intermediaries, to discuss, deliberate, or take action on any item of business that is within the subject matter of the state body. So let me stop there for a second. Sort of this question about what qualifies as a meeting under Bagley-Keene is probably one of the more important takeaways from this training that we give on an annual basis, because generally staff will handle like the posting of agendas and noticing of a meeting, but it is sort of, there are things members should keep in mind in terms of not sort of accidentally creating a meeting that would be subject to Bagley-Keene. Because a series of communications, including by like phone or email, can be considered a meeting, and if not noticed, would be a violation, it's important to sort of be careful about when you communicate with other members of COAF outside of a typical meeting. So other things to know is that documents, including emails and text messages of members, may be subject to disclosure under the California Public Records Act. That includes documents stored on your personal devices. It's not exempt from production just because it's on your personal phone, or it's not a State Bar email address. So always be mindful of what is written in emails regarding State Bar business. It's also important to know that a member's computer browsing history during a public meeting may also be considered publicly disclosable as a public email. Okay, so I guess the guiding rule is you shouldn't be sending like an email to all members of COAF, as that would likely be considered an improper meeting under Bagley-Keene. But what you can do when you have questions, for example, is to email staff. So there are certain exemptions to the meaning of a definition. Those include sort of individual contacts between members of the body and others that do not otherwise violate the Bagley-Keene Act. Attendance of a majority of the members of a body at a conference, training, or workshop. Open and publicized meetings regarding a topic of state concern organized by an outside group. Purely social or ceremonial occasions, as long as business is not discussed among members of the body. And if a majority of members of a body can attend an open notice meeting of a standing committee, as long as they don't participate. So it's like you could attend the meeting of another committee, and because a majority of COAF members attend does not automatically render it a meeting for Bagley-Keene purposes. So serial meetings are prohibited. So this is sort of the concern about emailing sort of all other COAF members. There's sort of a prohibition on situations where you could try to circumvent the Bagley-Keene requirements by having a series of conversations between members that on their own wouldn't be a meeting, but sort of as a whole, sort of provide a way to circumvent the meeting requirement. So again, just a reminder that you can email staff, but avoid sort of engaging in multiple conversations with other members of COAF outside of a noticed meeting. This Stockton case is just an example. An attorney in that case individually polled members of a body for their approval on a real estate transaction. The court concluded that a series of individual phone calls between the agency attorney and the members of the body constituted a meeting. So teleconference meetings. So under Bagley-Keene, meetings of the covered body can take place via audio or video conference so long as the meeting complies with Bagley-Keene's meeting requirements as well as additional requirements. So no surprise, we're on a teleconference right now, and we're doing so in a manner that's compliant with Bagley-Keene. The Bagley-Keene has long had a teleconference like compliant way of holding a meeting. But recently, in light of COVID and the sort of transition to remote work, there's been sort of those requirements have been in a bit of a flux. But recently, the legislature enacted a Senate Bill 544, which was effective at the start of the year, that allows members of boards and sub-entities to participate in meetings remotely without posting their locations. In given circumstances. So before, if there was a remote meeting, if you were attending from home, you would still have to put your home address and ensure your home address was ADA compliant. But now there are sort of more lax requirements, and what those requirements are depend on whether a body is considered an advisory body. And COAF, fortunately for us, is an advisory body because sort of it doesn't have the authority to make decisions on behalf of the state bar. So we're subject to the advisory body requirements for teleconference meetings. And those are the following. So if a body is advisory, all members may participate remotely without noticing their location or making the remote location available to the public. However, the names of all members participating remotely must be on the agenda at least 24 hours before the meeting. The members must also be visible on camera unless technologically impractical. So if you aren't able to appear on camera, but you want to attend, you must sort of out during the meeting announce the reason why you can't be visible on camera. At least one physical location must be noticed from which the public can participate in the meeting, and one staff member must be present. The teleconference information must be posted. We usually put that in our agenda. And if these requirements cannot be met, then all members must post their physical location. So voting. So Bagley-Keene also requires that voting can't be done in secret. Whenever we cast, it's why we do our voting by roll call. It's just sort of in the interest of public disclosure of the work that the votes are read aloud. So there are certain exceptions to the standard meeting notice requirements. So, for example, if you wanted to have a meeting under the 10-day notice required period, you can have what's called a special meeting. But these meetings can only be held if a finding has been made by 2/3 of the body that the 10-day notice period would impose a substantial hardship on the body, or where immediate action is required to protect the public interest. If a special meeting is held, at least 48 hours notice is required, and the rules around open and closed meetings still apply. The other limitation with special meetings is that they're only allowed to discuss certain types of topics. Those are pending litigation, proposed legislation, disciplinary action against an officer or employee, or license examination and applications. I understand these are pretty rare, but they have happened in the past. And notice that this is different from when you add just an agenda item to an existing notice meeting. There, the finding that is required is different and doesn't have these subject limitations. So there's also emergency meetings. So the Bagley-Keene allows for emergency meetings where there exists a crippling disaster or work stoppage that would severely impair public health and safety. So it requires a 1-hour notice to the media and must be held in open session. And the Act also sets forth a variety of other technical procedural requirements that must be satisfied for emergency meetings. I understand these are rare too, but I believe in the past, I think the board may have held these for COVID related reasons. Okay, yeah, so under Bagley-Keene, there's also a public comment requirement. A state body should provide an opportunity for members of the public to directly address the body on each open session agenda item before or during consideration of the item. This is not required if public comment was allowed during a committee's consideration of substantially the same item. And a state body may adopt reasonable regulations to govern the public comment, including limiting the time for particular issues and individual speakers. So that last bit just says that there's sort of discretion in sort of how we regulate the amount of time for public comment. So as I believe we do, we can say that a speaker is limited to like 2 to 3 minutes. If, for example, there is a high volume of people who want to make public comment, the body can say that there's a hard stop after 20 minutes, for example. Social media. So the use of social media can create the risk of inadvertent Bagley-Keene violations. So this sort of, again, like the hub and spoke issue. Social media comments and likes may involve communications among a majority of the legislative body outside of a properly noticed meeting. So if a member posts about a meeting on their Facebook page and 2 other members comment on the post and it's about state bar business, that is something that could be considered a Bagley-Keene violation as effectively a meeting. So the general rule is avoid liking and commenting on issues involving the state bar. Closed session. So closed sessions of meetings are meetings not open to the public. The grounds for having a closed session are limited to those that are found in the Bagley-Keene Act or in state law. There's a reference to state law there because there are set bases for closed sessions under Bagley-Keene, but there are also additional bases for that under the Business and Professions Code. So a closed session must be held during a regular or special meeting, and they may not be scheduled independently of a noticed meeting. And the agenda must indicate the specific grounds for a closed session after each agenda. So these are the available reasons for a closed session under Bagley-Keene. I won't read these all to you, but the big ones are if you're preparing or approving an exam, discussing something that implicates the privacy of an individual licensee, investment decisions, pending litigation, etc. And there's additional grounds under the Business and Professions Code, as I mentioned. For example, matters related to the Committee of Bar Examiners, or consideration of an applicant's moral character, or information about a law school's operation that constitutes a trade secret. So this is a bit out of date now. This is sort of a reminder because prior to 2018, these were grounds for closed session. But appointments, removals from committees or boards used to be grounds for closed session. They no longer are. And neither is appointment or dismissal of a non-employee consultant officer of the state bar. So the remedies for Bagley-Keene violation are that you can overturn the decision of the body or an action of the body. Sort of a bigger risk is maybe in the court of public opinion. We wouldn't like to hear the state bar is flaunting Bagley-Keene rules. Civil actions can expose the state bar to attorney's fees. And then there's, if there's a willful violation, it could be considered a misdemeanor. And that's my presentation on Bagley-Keene. Are there any questions? Great. Well, seeing none, I'll turn it back over to you all.
Thanks, Raul. And thanks for highlighting the parts that are different now for us that since we're considered advisory, that's really helpful. I know in the 5 years that I've been here, the rules keep changing. So it's good to get an update on that. I appreciate it. Thank you. All right. I think that there's Natalie.
And Lisette too.
And Lisette, and Lisette is back. Excellent. Welcome back, Lisette. And Natalie, you are still muted. There you are.
Hi, welcome.
Hi, Natalie.
I'm glad to
Natalie,
have,
it's nice to have you back.
I was just going to say, I'm glad to be here, glad to address you, and also to get some feedback from the group.
Well, you know, this is one of my favorite topics, and Sarah's as well. So we look forward to your update.
Okay, terrific. Thank you. Well, hello, everyone. For those of you who I know, it's good to see you again. And for those that I'll meet today, I'm Natalie Leonard. I work in admissions with educational standards, largely the accredited and unaccredited law schools, but also the ABA approved schools. So here, today I'm here to give you an update on the law school profile report and also the rules revision that is being considered for the unaccredited law schools. And the committee is considering several very broad, sweeping, changing options in the context of a changing legal landscape. So this is a time when we would particularly welcome your feedback and also any connections with the work that you're doing or the work that you see being done out in the field. Lizette, I don't know if you have also introduced yourself, please do.
Yeah, thank you, Natalie. Hello again. I'm Lisette, a senior program analyst in ORS, and I'm just here to support Natalie in case there are any questions. Thank you.
Lizette's very modest. She was deeply involved in the creation of the law school report, and we're glad to have her here today for deep dive questions on the data. I'm going to switch between two reports, so I'll ask for your patience up front as I move between the PowerPoint and also the interactive report itself. And both of these are going to be available to you. I think already the Folion interactive report is posted on your agenda. So I'm going to share my screen and get started. The little black bar go away. Not totally behaving, so I think we'll go like this because we won't be here too long. Okay, can everyone see my PowerPoint screen here?
Mm-hmm.
Okay, great. Okay, so for purposes of background, so just where we've been and why the committee is doing this work. Some of you may remember when we met last time, we talked about a rules revision and we were getting ready to go and start that immediately, but we realized that there was a need to add an additional step in the process, which was to assess the legal landscape, and we'll talk about exactly what that means. We zoomed out a little bit more at the request of the committee to think about their strategy for the year. So in the State Bar's strategic plan, this is a goal that's probably similar to your work too. One of the committee's goals is to collaborate with stakeholders in law schools to improve the law school accreditation process. And that accreditation process was meant to encompass both the accredited schools and the unaccredited. As you know, the unaccredited rules are in play, but the accredited rules were revised. They went through a 2-year phase-in process and they became fully operational in January of this year. On the Committee of Bar Examiners work plan, they have several items, of course, to fulfill these strategic goals and also to reevaluate not only the rules that govern the unaccredited schools, but the metrics that track their performance. There's also a thought to reconsider something that was considered back in the 2016 and 2017 timeframe, possibly encouraging or requiring unaccredited law schools to pursue a mandatory path to accreditation. So some of the data that we've been using is contained in the accredited and unaccredited law school performance report. This is an annual update that had been on pause for a while. but now it's going to be presented each year to the Committee of Bar Examiners, and it's something that we can bring to you as well at COAF. It talks about just overall performance at the category level, but also has a lot of detail at the individual school level, and we post this on the reports page where you can also find the law school profile. The law school profile is a little bit different. This is a one-time report. It's the focus of our discussion today, and it's the first time that there's been a comparison of the 3 types of schools, including ABA-approved schools in California. Why now? In part because over the last 3 years, we've been phasing in additional demographic data that more closely aligns with what the ABA captures on both a general basis and an intersectional basis. And so we're able to do a robust comparison in a way that we couldn't before. And at this point, this is when we showed the profile to the committee. But before we do that, I actually want to give you some more context slides, and then we will return to that profile. Because I don't know how familiar everyone might be with the accredited and unaccredited schools. So let's go here. I talked about how the landscape is changing in terms of the 3 types of schools, and I want to say exactly what I mean so that you have this in mind when you're looking at the law school profile and thinking about what suggestions you may have for the unaccredited category of schools. In the past, the unaccredited schools had a unique role that no other could serve. Unaccredited schools were the only schools that could offer a a distance program. So they all could offer a fixed facility program. And in fact, accredited and ABA schools were required to have a fixed facility classroom type of program, but only the unaccredited schools had distance. Since 2020, the accredited schools have been able to have a distance or a mixed modality program. So that's something unique that the unaccredited schools cannot do to the same extent. And very quickly, we're seeing the ABA schools phase in something similar. So previously, very little distance was allowed. They moved to a 33% general commit. Now 50% of an ABA school JD program can automatically be online, and 100% with a variance. There are 2 sets of proposals at the ABA right now to contemplate that perhaps in the future, if approved, ABA schools may be approved without a physical campus. So there may be ABA schools in the near future more like months, years, as opposed to weeks, that have a distance type of program, and particularly a couple of programs now, but starting in the fall, you'll start to see California programs in Southern California and also Santa Clara Law here. Also, similarly, unaccredited schools were a large source of part-time programs that generally weren't available. Accredited schools have always been able to offer full-time and part-time, but focused on the full-time, they're offering more and more flexible part-time programs with the advent of the distance choice. And the ABA schools had very, very few part-time programs before, but many of these new hybrid programs that are being introduced are in fact of a part-time nature, or also a shorter nature, as short as 2 years with the summer included. There's a program like that at Southwestern right now. So there's a huge amount of change in this sector right now. Any questions about just that landscape? Because we're looking at a situation where that was necessary for the students that needed distance or correspondence, but that's no longer true. So we're just asking the committee to reevaluate what is the positioning, what is the necessity for unaccredited schools.
Yeah, I mean, I think, the landscape has changed, since we started doing this work together, Natalie. And, to your point, I think, this is something that COAF should be thinking about, and I would love to hear more. I know that Shalak and I are both the liaisons on this. But I think COAF will probably have some thoughts on this moving forward. And it will also be interesting to see how this dovetails with any changes to the bar exam itself. Because, you know, many of the changes to the bar exam itself were suggested by some of the deans at the unaccredited and registered schools, so.
Yeah, that's also true. So you can see why it made.
I think Novell has a question. Hold on one second, Natalie, I'm
Oh,
sorry.
please.
Yeah, I just had a clarifying question about the terms. Can you give examples of like what the distance learning program would look like? I'm assuming it means like you mail stuff in or like online things, but I realized I really didn't know.
Okay, yeah. So fixed facility is basically a classroom. You go, you attend a classroom, everyone is in the same space, and that learning happens in that manner. Correspondence has been around much longer. That was the historical, you receive the box, you fill in the materials, you send the box back. We don't see that nearly as much just due to changes in technology, but we do see a little bit of that, and it allows a more self-paced option. And then the distance learning option is a combination of synchronous or asynchronous learning. So it could be tapes, it could be interactive static media, or it could be distance learning, you know, much like this, where there's an interactive type of thing online. So the distance could have different meanings at different schools. It's more elastic. And different choices in that distance category offer a different flexibility of time. Must be there on this day at this time for the interactive section versus must complete this work in this period at your choice of times. So I think that flexibility option is something to think about. So the committee said before they set off changing the rules, let's just take a moment and get a sense of what's going on in each of these categories. The data that we used here is 2022 data. We're in the process of getting some limited updated 2023 stats. The State Bar collects annual reports from September to September each year. So the most recent annual report we have is from November. And in the coming months, April and June CBE meetings, we'll be looking at the updates. But early review of that data suggests that the trends that you see here are expected to continue in that 23 data. So they're reasonable for you to use to start thinking about your feedback and your strategies that this calls to mind. Okay, so any other questions before we go to the profile report? Okay, the profile report is a lovely Folion interactive report. It makes it actually a little bit more challenging to show to you in this forum. But when you go to look at it on your own later, this format is really great to work with. And I think it's going to help the important data and the context stand out. We're not going to start reading, we're going to start chatting. But as far as the executive summary, I think this is one of the most important pages in setting the stage in the whole report. This is basically a funnel looking at students at each type of school and being aware that students may be different in terms of demographics, in terms of age, in terms of family commitments, etc., at each of the types of schools. But you can see that when someone starts at an ABA school, at this point, ABA schools are contributing about 69% of our ultimate students in California and 87% of the JDs awarded. In terms of attrition, they're generally getting through and completing their JDs, having an opportunity to license. Attrition for the first year students And first year is where we see most of the attrition across all of the categories is 8%. We see something much more significant in the CALs and unaccredited. So we see just 1% of JDs in California coming from the unaccredited schools right now, 12 times that from the accredited, and the majority from the accredited schools. And you know what, I'm actually going to pose a strategy question early on, so you will have this in your mind when you're thinking about it. Something that comes up at the committee from time to time that is an active consideration right now is determining the role of the committee in balancing whether to allow students an opportunity and just be clear with them about what the attrition rate could be. You see those numbers here, which are substantial, versus having some sort of ceiling as to what is acceptable in terms of consumer protection. And there are arguments on both sides. And I think it's a good frame for you to have as we are continuing to talk about this.
Can I ask a follow-up question to that, Natalie?
Sure. I'm going to just turn this off to see you
sure.
when we do that.
That's fine. So on that slide, one of the things I had to, when I looked at, I was very excited to see the report. I know it rolled out, I think, right after our last meeting.
Right.
And the executive summary is very helpful too. But on that first slide, I know I had to look at it twice because the percentages that are on there are percentage of all law schools in California. So when it says the attrition rate, for instance, at unaccredited schools is 51%, that's of students that are leaving law school, 51% of them are leaving from unaccredited schools. Not that 51% of students at unaccredited schools are leaving in the first year, right?
Oh, that's funny. I read it the other way.
I think it's actually within the class. I'm going to double check.
I thought it was 51% of their class was leaving.
That's how I read it too, that 8%
Well, that's a great question, Michael. Thank you.
It's
Yeah,
first
it's actually,
year attrition. Oh,
It's
go ahead.
first year attrition from that class of
First year
students, right? So 51% of unaccredited students are leaving in their first year. Okay.
So is that because they all add up to 100%, I think? Maybe if we look at the slide, that'll help you understand.
I think that might be by chance and maybe not by intention. But that's a good question, Michael, because I read it differently than you did. But you're right.
okay, Lizette, I'm going to turn to the expert here, but we're thinking about this part,
Well,
the attrition.
but all of them. So if you like bar pass rates, is it that 9% of unaccredited students are passing the bar, or is it that of those that passed the bar, 9% came from unaccredited schools?
Well, it doesn't add up. Does add up.
It's close anyway.
It's 88.
Yeah, I think that's across like all first year. That's the attrition rate for per type of school. So let me just confirm that and then I'll get back to you.
And maybe that's just I don't know if it's...
It may just be serendipitous that it turns out to come close to 100, but it's funny because I read it differently, but it isn't, but it does make a difference. You're right.
And you know what, Michael, we can also pull up the stats numbers that are on the admissions website to compare at the end of this, just to be sure.
Yeah, it's all attrition in first year. That's the percentage that they make up across the different types of schools.
So 51% of the attrition of 1Ls
came
is
from unaccredited.
Okay, so it is the way Michael thought. Okay. So 51% of attrition is in first years is coming from the unaccredited, and then the 42 is coming from the Cal registered.
And I also think that something that's helpful to know is that when you're looking at the unaccredited category, this category is subject to the first year law students exam. So after they finish their first year, they have 3 opportunities to take and pass the exam. And passing that exam is a reliable indicator of their ability to eventually pass in the future. If they don't pass between the first opportunity and the third opportunity to do so, then the law school is required to dismiss them, and they can return to law school after a 2-year waiting period. So unlike these other 2 categories of schools, you will also see 2L attrition of a reasonable size from the unaccredited category. So it makes this gap actually bigger than what you see here if you look at it in context over a person's law school career.
That makes sense.
Mm-hmm. Okay, so these are very large graphics. We're going to slide down into them. So California has 48 law schools right now. This number is continuing to decrease across most of the categories. The CALS category is growing, and it's growing from both sides for a couple of reasons. We're either seeing unaccredited schools promote up into the CALS category, or we're also seeing some ABA schools decide to join the CALS category. And our overall universe is about 17,000 students in 2022. And as you know, that number is dropping.
Can I ask a question?
Oh, yeah, sorry, go ahead, Shalak. I was just about to stop Natalie and ask her.
And you may tell me, Natalie, that it's more appropriate for another time. I'm wondering if there's anything, or this might go to the strategy question that you were raising earlier. What are the boundaries around ABA accredited schools be moving from ABA accredited to CALS accredited? Like, I am going to sound crass saying this. Is it because they couldn't meet the standards to remain accredited by the ABA? And so next best thing is CAL accredited because the standards aren't as strict? And I'm so sorry, I don't have a better way to phrase that, but I didn't mean to sound disparaging. I'm just like truly, or do you like, is there anything around, is there an application to move from that? Is there something? And this again might be the strategy question you were talking about.
There is an application to move from one to the other. So we've seen 2 moves so far. In both cases that the ultimate pass rate, which is the pass measure that the ABA uses, was at play. In one case, the school was actually released from ABA approval. They were not meeting that number, but they could meet the pass rate that's required of accredited schools. In the other, it was a voluntary move, but they were on a path where they were being scrutinized as to their pass rate. That one was a community-based law school in an area where there really are not other law schools. They wanted to continue to be largely in person and community-based, and they felt that they could not meet the ABA standard if they kept that as part of their mission. So that's what we've seen so far. So I do think the pass rate does matter.
I was muted. Sorry, I was saying thank you. I didn't realize I was muted.
Oh, no problem. Okay. The other thing you'll notice is there's a significant difference in the cost to complete the degree. But I want to highlight a little bit of dig deeper information that we probably would want to include in a future report. When we look at the gap between ABA approved and CALS schools, that gap would actually be closer. A CALS average would be closer to 100,000 if we removed the couple of distance schools that accredited recently. And when they moved over, they were able to keep their relatively modest tuition profile. And they're both very large. So large that they actually dropped this number somewhat. And if we look at the unaccredited, this tuition number looks extremely attractive relative to the ABA approved number, but we are having the biggest performance challenges at the schools that have the most modest cost, and several of them are already slated to close, that were open in the 2022 data, will be closed by the end of 2024. So I do think that you will see these numbers increasing, but not to this level. Any questions about the tuition?
Natalie, and I don't know if you know the answer to this, but is the financial aid that's available to these law students the same at all three? I don't think it is, right?
No, at the ABA schools, they all participate in Title IV, so they all have federal student loans available. At the CALs, most of them do, about 3/4 have federal student loan availability. At the unaccredited schools, there are 2 out of 12 that have federal student loan capability. When there are no federal student loans, the schools generally utilize payment plans or private loans, which would likely be higher interest if the student can't pay directly. And Novella, is there a question?
Yeah, is the total cost column just tuition or is it everything?
It's tuition and fees. There's not a room and board component that's included here. None of the accredited or unaccredited schools have a dorm type of situation to figure into that. So none of the fees, including the ABA, include room and board, but all our tuition fees, just not books. To the extent a program still has books. Sarah?
Yeah, I had a question in the average total cost to complete for the unaccredited, since so many drop out after their first year. Would it be fair to say that the $33,000 number, you just divide that by 3, and that would be the cost of a first year for somebody who potentially failed the first year exam and then had to take 2 years out to complete law school, or what does that mean?
A good question. On track, I would suggest dividing by 4. Reason being, all of the unaccredited schools are required to have 4-year part-time programs. The CALs would have a mix of 3 or 4-year programs. So yeah, about 1/4 of that would be incurred in that first year. So they would leave having paid that amount or having that trailing loan. Okay. Okay, you're going to see a big change here in terms of enrollment in recent years. We went back as far as 2009 because I'm sure that many of you remember the upheaval in the general market at that time. So you see a big change in the number of law schools in general, in all categories, in the total JD enrollment. So here's what we remember from the ABA schools. But look what we see here. A big increase in CALs, but really that is coming from, like I said, influx from either side in the CALs category. And that corresponds with what you would expect in the unaccredited category, about 3,300 in 2009, down to 627. And at least one school representing about 1/4 of this number has expressed interest in accreditation. I'm not sure whether that will come to pass, but that's a current pressure or interest in the unaccredited category. So we're seeing its unique positioning for unaccredited changing. It no longer has a unique stronghold. It's contributing just about 70 degrees per year. You'll see that in a moment. And it's about 600 students versus these larger categories. And so that's why the committee is really reconsidering the overall positioning. Okay, so the next thing we did was take a look at some of the attrition data by demographics. And when you see us look at people of color as a whole, it's because the data was of a size that it was more helpful to aggregate it. So that's why you see that there. When we were able to share more detail, we did. So overall, if we were to look at CALs or unaccredited, we would find that they are more diverse at the time of entry when they begin in their first year. But once we factor in the attrition, that's not as true as it once was in the past. So here in the unaccredited area, where some of the student body is the most diverse, we also see absolutely the highest attrition among people of color. So they are joining in the program, but there needs to be improvement in the ability to keep them in the program. Curiously, we only actually, well, we have long looked at the progression from 1 to 4. We've only recently started to track the JDs awarded, and not everyone gets from the 4th year to actually completing that 4th year successfully. So this JD awarded number is actually new for us. And so if we look at 2022, 87% of the JDs came from ABA schools, not probably very surprising to anyone. 12% from CALS, 1% from unaccredited schools. Any questions about this generally? Or are people surprised? Is this what you expected?
I don't think I expected the number of people enrolled in the accredited and Cal schools to unaccredited and Cal schools to be as high percentage wise as it turns out to be.
Oh, okay. That's interesting.
Which is interesting because, as you know, I probably spent more time than most people in COAF on this issue. I don't think I'm surprised particularly that almost 90% of the JDs awarded though come from the ABA schools.
And numbers I focus on really are these: 27% of students, 12% of degrees, 4% of students, 1% of degrees.
Yeah.
As I'm sure you do too. There are many different ways to look at pass rates. We could have a whole meeting just on the bar exam and the pass rates, but a couple of key things to point out. This is just looking at one exam. This is just July 2022 as an example. And we're looking at the number of first-timers versus repeaters taking the exam. So this is something else we see. For those unaccredited graduates that do earn their JDs, it's taking them longer to pass the bar exam than either those at CALS or those at ABA approved school.
Natalie, can I interrupt you just there? Because
Yes.
I have a question, slight concern. So if both the Cal accredited and the unaccredited are required to do the first year law student exam, right? And they have
Just the unaccredited, unless it's a special student at CALS, and there are very few of those.
Okay, so sorry, that then maybe clarifies where my question was going. If it's supposed to be a good predictor, I guess it troubles me that there's still such a low passage rate for them, at least on the July bar, right? Like presumably those who took the bar exam for the first time coming from an unaccredited school passed the first year bar exam, which is supposed to be a more reliable indicator of their ability to pass the full bar exam in order to be licensed. And so does that mean that we need to be doing closer review of whether or not the first year bar exam is adequately or accurately assessing that? And again, this might go back to your first question around strategy, right? But I guess my larger trouble also goes to the previous slide, which is sort of the ethics around people enrolling in something that we see doesn't necessarily trend to graduation or bar passage. And knowing that many of those are first generation and or people of color and or people from lower socioeconomic status.
Well, Dalak, I couldn't think of a more meta question, because as we're meeting here, actually at this very moment in the Committee of Bar Examiners, they are specifically discussing the composition and the appropriate standards that should be set in the first year law students exam. The format's going to be changing to an all multiple choice exam for this year for a number of reasons, which I'm sure we could bring back to you to talk about if you are interested. One of them being the consumer protection element, to make sure that the schools have an indicator of their performance, but also the students have an indicator of their progress. And we did a study, I want to say about 2 to 3 years ago, and found that for those that do not pass the bar exam, the first year law students exam, and begin again, it's challenging for them to persist. So I think your point is very relevant. Did I see another hand? I think I saw one go up and down.
That might have been me.
Okay. Okay, thank you. Okay, so again, this is just the July 2022 bar exam. And you can see the first time repeater total pass rate for the different types of schools. And it is quite different between them, but also the measures that the accreditors use for each type of school is quite different. And you'll hear more about the minimums, and I like your opinion on some minimums for the unaccredited schools as we get there. So we talked a little bit more about enrollment. I just want to point out for those that want to take a look at this, that there is, you know, a little bit more of a deep dive in here. But we did talk about some. In terms of next steps, there is a short list of next steps here, but I'm going to take you out to the larger group that we're sharing with the Committee of Bar Examiners and some of the live proposals that they are thinking about right now. Okay. So let's go here. So we put several possibilities before them. The first one was to think about what's going on in the unaccredited segment, and are there elements from the accredited segment that should be ported over into the unaccredited rules. And we talked about some of the things that are different and considered many of them important and of interest. The one that the committee zeroed in on was thinking about whether or not a mandatory pass rate should be added to the unaccredited schools, because right now they do not have one. So ABA schools have a 75% 2-year pass rate requirement. So if you're in the class of 2022, by 2024, if you've chosen to take the bar exam, 75% of graduates must pass. For the CALs, there's a more modest 5-year cumulative 40% pass rate. So we like how the NPR has been working for the accredited schools for a number of reasons. First of all, it's aligned with a goal of licensure. It's been flexible. We've been able to incorporate the provisional licensure program for those students that were in the expanded program that were able to license without bringing in another bar exam. We also saw some really functional changes that schools made voluntarily. They improved the bar prep for the bar exam, particularly in the Cal schools, not only for their current students, but also for their alumni. We saw a tightened commitment that they didn't have before. And that's important when you have a larger percentage of repeaters in your taking body for each exam. We also found it really easy for prospective students to see the numbers and compare across schools when they were choosing. And we see the NPR results continue to increase at most, but not all. And when a school exits the category involuntarily, they have a really clear understanding of how that happened. And so far, 4 schools have exited out as a result of inability to meet the NPR. So one of the proposals that they're looking at right now is adding a cumulative pass rate for the bar exam, but also for the first year. So this gets back to Shalak's point of view, to place additional highlight and clear regulatory standards on preparing students for that first year, and then continuing on for later. And I think that one thing that's nice about this type of measure in general is that it can affect every single part of the chain that can result in improved results. So hopefully there is more scrutiny at the time of admission, and schools have a lot of flexibility as to admission based on their mission. But what we ask of them is, when you accept a student, please be sure that the resources and focus of your curriculum are what that student needs. So if you accept a student that there's a possibility to accept students that have just 2 years of preparation versus a BA in these schools. So in that case, be prepared with very strong academic support, be prepared with very strong waypoints along the way. Admit those students that you can reasonably teach and reasonably give an opportunity for success. Minimum pass rate hopefully will improve the results on the first year law students exam, and getting past that point, hopefully help them to progress, to graduate, and then move on to licensure. So that's one measure that this committee is thinking about. Any thoughts about this as a measure, this as a point of view before we go on to the next initiative they're thinking about?
A question about the consequences, I guess is the word. If, for instance, the unaccredited schools were required to have a minimum pass rate, would the hammer be that their students couldn't sit for the bar? Is that how it would work?
It doesn't so much work like that, at least in the accredited schools right now. So they had a part in having a runway to get ready to meet that requirement, and it's a requirement for them to stay open. So it's really got to do with the law school's operation. The students wouldn't be barred from continuing, but the school might be barred from continuing to operate. So far for the accredited schools, when they have fallen under, they've been given 2 years to improve. And that's similar to what the ABA has done as well. And one school has been able to move and return to compliance, and then 4 moved to the unaccredited category. So it's definitely not meant to hurt the students in any way. Shalak.
Yes, I have a follow-up to Judge Rhodes' question, which is, so what about those unaccredited schools, right? Like, we understand this isn't meant to harm the students, and I think that's exactly right. But what about when a school moves from the accredited to the unaccredited category, or is already in the unaccredited category and isn't meeting these? Is there some type of enforcement mechanism from the state bar, or could there be from the state bar towards the school? And I think this goes to some of that consumer protection. Like, at what point does the state bar say, this is not good for those seeking to be attorneys to be using time and resources to attend a school that we have documented data is not fulfilling, ultimately getting these people to licensure?
Well, right now, there are sound education standards, and they're designed to be clear and rigorous, but also give some flexibility to have different missions at different schools. But it can take longer to address enforcement in that type of case. So we think that adding these minimum pass rates will allow schools to have more notice, to have a clear self-regulating thermometer, and make it easier for the state bar to take action when it needs to, for exactly the reasons that you described. That's one thing that we're hoping, but we also hope to be supportive, and that leads me to the second of the 2 possibilities that the committee is thinking about seriously. And this is one that we've thought about before, but it would definitely require some statutory changes to happen. And that's creating a mandatory pathway to accreditation. Going to skip over the background slides that we have already looked at. But in the past, when the segment was larger, it was considered, but at that point, we didn't really have a proliferation of the online programs yet. And most likely there was some concern that geographic areas in California might be underserved. And without having that concern anymore, due to the proliferation of the online programs, it seems time to think about mandatory accreditation again. So that's not a specific measure, but it's a way to encourage continuous evolution for each of the schools. And it's a way that the state bar can do that supportively. But we do see the segment getting smaller. We do see all of these students having other online options without leaving their home area if they can't for whatever reason. we've seen 8 out of 10 schools in the unaccredited category, I say 10 because 2 are closing, at least express some interest in accrediting, whether or not they're able to do so today. And we think that we could include a transition plan for each school as part of their normal periodic inspections. We also think that the State Bar might save money by having a single set of rules that is being enforced, but it would require a statutory change. So those are the 2 things that the committee is thinking about right now. And then we received a question just today. So here's a hot off the press question. We've experimented at different times with whether or not an entrance exam should be required. All ABA schools are required to have an entrance exam. It used to be only the LSAT, more recently the GRE, and most recently with a variance, ABA schools can use a JD Next program. So that's actually a little course resulting in some essays that are not specifically graded. And that program hopefully reduces any sort of racial bias versus any other type of exam. So the committee asked some questions about adding an entrance exam for this category of schools as well. So I wondered if you had any questions or concerns about supporting the unaccredited schools to raise their standards to the level of the accredited schools, or if you have any plus or minus concerns about maybe reinstating the entrance exam as a means of hopefully giving a barometer before the student starts and giving an objective standard to the school as well.
So Natalie, can refresh my memory on the diversity requirements for the unaccredited versus the Cal bars. Because I know that some of the unaccredited schools have exclusionary admission policies, put it that way. Would a path to accreditation change the exclusionary admission process, or would it still remain the same for those schools?
A slightly complex question.
Sorry.
The unaccredited schools do not have a specific diversity plan that they are required to write down, though you can see that the unaccredited schools have the most diverse student body at the start. The accredited schools are required to have a written diversity plan with metrics. They are required to show their analysis of the metrics and the reasons why they've made changes or haven't made changes as the result of what they've seen. What doesn't change is that if a school chooses to incorporate as a religious corporation in California and follows the requirements of being a religious corporation, it'll still be able to continue within the bounds of that format. And that's not to do with the state bar's policy, it's to do with the law of the state of California.
Thanks, that helps.
Okay. So those are really the 3 things that we're thinking about that the committee is actively discussing. Mandatory accreditation, a longer term, medium term could be the addition of entrance exams as well as minimum pass rates. And we would appreciate your opinions. We would appreciate your support in helping folks to brainstorm about other ideas that may not have yet been considered. And we'd love the opportunity to keep you in the loop as the dialogue continues.
Yeah, I think we would like that too.
Mm-hmm.
And I know that Shalak and I are the liaisons to this on this issue, but if other people have thoughts, I know Shalak and I probably have lots of thoughts, which is why why we're on that. But if other people have thoughts, please reach out to Shalak and I or Natalie on this.
Yeah, and as far as where the committee is going from here, they had this presentation in January, and in April they're going to be having more of a deep dive discussion, making plans and strategies for these 2 initiatives, and hearing a little more data on the use of possibly an admissions exam or not. So stay tuned, and we'll also keep you posted as to the agenda item in case anyone wants to listen in or to see the tape, because of course, like this meeting, it'll be webcast recorded. Shalak?
Yeah, I was just wondering if the committee is, I'm sure you are, because you all are very well resourced, but connecting with Access Lax on any of, they are doing research right now and proposing some other programming around the efficacy of admissions exams in predicting bar passage, first year success and then bar passage. I mean, they're geared towards ABA schools, but I think connecting with them as the committee might be considering admissions exams for the other schools, right, Cal accredited or unaccredited, it might be useful to see their work around JD Next, and they have a Lex Scholars program, and some of the other things that they may be doing that perhaps the committee might recommend even for a Cal accredited or unaccredited to do to boost first year passage of that first year law student exam, and ultimately bar passage, as ways of, despite how I might feel about it, as ways of maintaining those schools as viable options that are also not predatory and actually set people up for success. And so I'd really recommend the committee or who's ever looking into that, connecting with Erin Taylor, who's now the executive director at Access Lex, but was leading a lot of that research. I think it might be helpful in thinking about ultimate student success.
That sounds like a terrific resource, and literally this request is only a couple of hours old. So I am definitely grateful for suggestions and resources. Novella.
Yeah, I feel like I'm still trying to figure out what my question is, but just to frame it broadly, I'm wondering how the work of this committee or working group relates to the other efforts about success on the bar exam and ensuring passage rate. So maybe my question is like how you guys approach the work, given that like the issue of whether the bar exam itself is a effective tool for deciding who becomes a lawyer is like something that is ongoing.
We approach it frankly in parallel tracks. So the bar exam is being examined, the first year is being examined, and then the rules that govern the operation of schools are being examined in all three tracks at the time. And it's important for the schools to operate in a manner that students have a reasonable opportunity to license via whatever manners are operative at the time. And then separately, any initiatives related to the exam instruments or portfolio instruments or whatever may be in play are being examined on their own merit, not necessarily directed by the schools, of course. So all of those things are going on at once, but it's important. Sometimes what some people will say is a student may graduate and may not be able to license, but having the JD may be valuable to them. But it is also somewhat of a circular argument that part of why it's valuable to them is because it represents a particular package of skills and abilities that are developed during the JD process and the reasonable opportunity to license. And so when the JD program doesn't offer those skills, then out in the market, it may not be perceived in the way that one would hope and may not offer that social mobility or that family improvement that might be needed. So yeah, the schools are basically looking at what is required today, and then separately admissions is looking at what will the bar exam of the future be. And then as it changes, the school rules also evolve. And in fact, one of the items on the work plan is to think not only about the licensing, but the curriculum as the Supreme Court considers the blue ribbon recommendations. does the overall JD curriculum have to change? And at this moment, we don't know, but we're certainly poised to try to react in terms of the rules when the Supreme Court does act. Does that address where you're going? Yeah, okay, good, thank you. Okay.
Any other questions for Natalie? Natalie, I just whispered over to Elizabeth to ask if we had a meeting scheduled with you. And I don't think we do, but I think it would be helpful if in your very busy schedule, you could maybe find some time to meet with Shalak and I.
So Natalie, I'll reach out to you to coordinate that.
That sounds perfect, and the timing is perfect too. Okay, well, I appreciate everyone's time and engagement, and look forward to working with you on what's next.
Yeah, and that's an amazing report, and the interactive part is super fun. So thank you for that.
Well, I want to thank Lizette and all of ORS in partnering with us and becoming in some sense their own admissions experts in order to do this. So greatly appreciated.
Thanks, Lizette.
All right, take care, everyone.
Thank you, Natalie.
Thank you. Okay, bye-bye.
So what we had next were liaison reports, and that Judge Dolchis has already given hers. And I don't see anyone from any of our other liaisons, do you?
No.
Okay. Then this is the portion of the meeting where we adjourn because we don't have anything else on our agenda. Does anybody else have anything else? Raul just told us we can't add things to our agenda. For those who were listening to the Bagley-Keene training, we can't just add things to the agenda. And so we are through our agenda. So we'll, do I need a motion to adjourn, or can I do it all on my own?
You can do that.
I can. Okay. All right. Then for the good of the order, I will go ahead and adjourn this meeting. Thank you all for being here. Thank you all for all of your excellent comments and ideas. We will meet again as a group on June 28th in person. Hopefully you can make it to Los Angeles to do that. And anything else, Judge Rhodes, that I'm forgetting? Great. All right, everyone, thank you so much. Thank you, Judge Dolchich, for still being on here. Thanks, everyone. Have a good weekend.